Vaibhavi Madam, good morning.
Good morning, sir. Good morning. Very good morning, sir. Sir, good morning.
Good morning, sister. Good morning.
Good morning, Lordship. Principal Distinguished Mahisagar.
Huh?
Principal Distinguished Mahisagar. H.A. Dave. Good morning, Lordship.
Okay.
Good morning.
No, Member Secretary, can we start the project director, the computer?
Yes, ma'am. Yes, my lord.
Kindly.
Petition
The
of
Honorable
Honorable
permission.
Chief Justice Sri Vikram Nath sir and Sri Dr. Vinit Kothari sir. Shall you start this webinar, sir? My lord.
Yes, yes.
Kindly.
Yes. Very good morning to all dignitaries, distinguished guests, and participants present in the today's webinar. It's a great pleasure for me to welcome you all for this webinar on re-energizing mediation post-COVID-19. Today, it is a matter of immense pleasure that our respected Chief Justice, High Court of Gujarat and Patron-in-Chief, Gujarat State Legal Service Authority, Honorable Mr. Justice Vikram Nath Sahib and Dr. Justice Vinit Kothari Sahib, Judge High Court of Gujarat and Executive Chairman, Gujarat State Legal Service Authority, and Mr. Hiralal S. Patel, Chairman, Bar Council of Gujarat, are amongst us to bless the occasion. Welcome, my lord. It's my pleasure to introduce Honorable Dr. Justice Vinit Kothari sir, Executive Chairman of Gujarat State Legal Service Authority and Senior Most Judge, High Court of Gujarat. My lord was born on 2nd September 1959 at Jodhpur, Rajasthan. His lordship had accomplished the qualification of BCom Honours, LLB, LLM, PhD in tax laws at Jodhpur. His lordship is also a qualified chartered accountant as well as company secretary. His lordship is also the honorary director on the board of International Association of Tax Judges and member of CMJ London. At present, my lord is rendering his duty as Judge High Court of Gujarat from 4th January 2021 and as an executive chairman of Gujarat State Legal Service Authority from 27th January 2021. Now I will request Honorable Dr. Justice Vinit Kothari sir, Executive Chairman, Gujarat State Legal Service Authority and Judge High Court of Gujarat for his lordship's welcome address. Sir, please.
Thank you. My Lord, Honorable the Chief Justice, Shri Vikram Nath ji, my esteemed brother and sister judges, all learned principal district judges, secretaries of the district legal authorities, and all members of the judicial family in all districts, Mr. Hiralal Patel, Chairman of Gujarat Bar Council, all learned advocates, trained mediators, and members of the audience, either in Zoom meeting or on YouTube links. A very good morning to all of you. I'm indeed very grateful and gratified to welcome my Lord, Honorable the Chief Justice, Shri Vikram Nath ji, Chief Justice Gujarat High Court, who has very kindly consented to inaugurate the 2 days online webinar based on the theme Re-energizing Mediation Movement post-COVID-19. As you all know, we are passing through a very bad phase of Corona Kal, and despite all odds, the basic human nature of survival guides us to fight back and survive, even in tough times, and thanks to the scientists and technology who developed the soft technology to hold virtual meetings and webinars, whereby the communication was not lost and has continued to be rather easy. It has not died down, and while the absence of physical meetings in this period have even changed the social behavior of human race on this planet. Since the nature tells us not to stop, the judicial institutions in India have taken lead in their own manner to hold the courts, lok adalats, and even mediations on online platforms, though at a lower scale of numbers. In Gujarat, when I joined on 4th January 2021 and was given the responsibility as executive chairperson of Gujarat State Legal Service Authority, I found that Gujarat was earlier a very great leader in mediation movement in our country, But of late, the said movement had gone in a little sleep mode, which I thought it was my duty to awaken and rejuvenate. Fortunately, with the proactive approach of my Lord, Honorable the Chief Justice, and very active logistic support of the Member Secretary, Mr. H.S. Mulia, and all district legal service authorities headed by respective PDJs and full-time secretaries there, I could put some speed and movement in the said ADR mechanism of dispute resolution. I have already held online meetings with all the DLSs and have visited at least 10 districts out of 32 districts in my short tenure of about 8 months in this High Court on weekends. And while this gave me not only an opportunity to come into close contact with the judicial officers of the respective districts, and I could also take stock of the ADR activities at district level, but I could also visit various parts of this most vibrant and developed state of our country. During such meetings, I could persuade the referral judges and mediators in all these districts to take up the said movement in a more speedy manner by referring more and more cases to the mediations and organizing the meetings of the parties in a proper coordinate manner. By giving away certificates of appreciation to the leading mediators and PLVs, we could also encourage and motivate other members of the team to give their best. In my own court, whenever a civil dispute comes before us in the form of first appeals or even letters patent appeals, if we find the elements of amicable settlement available in such matter, and if the respondents are even if government departments or government undertakings, we have tried to persuade the learned counsels to not only advise their parties to take their consent to refer the dispute to mediation, even at the hearing stage, and to credit of very decent and proactive members of this bar here, I must say, I have never received a negative response from the learned counsels, and some of the referred mediations have even succeeded in amicable settlement of the dispute. A settlement of the two sects in a masjid at Navsari recently is a case in the point, and some of the matrimonial disputes and property partition disputes have also been settled. The present webinar will have the blessings of the brother and sister judges, whom we made a request to chair and co-chair the technical sessions, and I am beholden to my brother and sister judges who so readily accepted my invite and immediately gave their consent to discharge the responsibility of chairing the technical sessions despite their overburdened schedules. Other honorable judges will also, I am sure, will make their useful interventions in the technical sessions, even in these 2 days. The success of any movement is always the joint team effort of all the stakeholders, and therefore, right from the staff of legal service authorities, including the two project directors, Mr. R.K. Mode and Mr. V.V. Monde, who are comparing these events for these 2 days, the team of trained mediators, learned advocates, disputant parties, and with the active cooperation of referral judges and my esteemed colleagues in the High Court, headed by wonderfully cooperative Chief Justice, there is no doubt that we have not only been able to put the life and speed in this movement, but have been able to organize this online webinar for this weekend, where 6 technical sessions are spread over these 2 days between 10 a.m. and 4:30 p.m., which will be attended by trained mediators, referral judges, advocates, university professors, and students, some of other sections like chartered accountants, industries, etc., to whom we have reached out and sent YouTube links, where this webinar is being live streamed, and those who want to join on Zoom link have also been provided Zoom links also. We have picked up the best of the lot of the speakers in this webinar, and all the 5 iconic figures in the field of mediation in India are very senior mediators in the country, and my friendship with them in all the 4 high courts where I've served has inured to our benefit in Gujarat State Legal Service Authority. I could obtain their consent on a mere telephone call, and I express my gratitude to all the 5 learned speakers. The first is Shri Niranjan Bhatt, the senior most but the youngest at mind and heart gentleman from Ahmedabad, who virtually held my hands and put me on the path of mediation movement in the state of Gujarat. I may also inform the august audience that Mr. Niranjan Bhatt has completed 87 years of his age only yesterday. So a belated and happy birthday to Mr. Bhatt from all of us. May God give you the full century of very healthy life ahead. Another senior advocate, Mr. Paresh Jani, a PhD holder in mediation subject, also practices in Ahmedabad as senior counsel. My guide and trainer in mediation training, which I took in Madras as sitting judge, Madam Sushila ji, is the backbone of Bangalore Mediation Center, and she is also there. She is also designated senior counsel. Madam Sadhna Ramchandran and Mr. J.P. Singh, both the learned senior counsels, are two leading figures in the field of mediation from Delhi. And as we all know, Delhi Center is doing the best in the country. So we have the iconic figures there to guide us in these 2 days. You will not find a single conference or seminar on the mediation in the country without the presence of all or some of them. Though I would have loved to include even leaders like Mr. Sriram Panchu and Mr. Jawad from Madras also in this webinar, but due to paucity of time and duration of this webinar, I could not do so. But this time and the other circumstances permitting, nothing prevents us from holding such other online webinars for the benefit of all stakeholders. The technical sessions, I may briefly tell the august audience here, will touch upon the important topics like landscape of mediation in India, why training of mediation is necessary, conflict in the context of mediation, overview of the process and stages in mediation on today, that is 26 June, and on day 2, tomorrow, Sunday, the topics will include tools and techniques in mediation, negotiation and bargaining, and communication. And for judicial officers, all of you here, 5th and 6th technical sessions are especially designed to train them for online mediation and post-COVID-19 challenges, and about private and pre-litigation mediation. The 6th session will have 2 parts. Part A will be discussing role of the referral judges in promoting mediation, and Part B is open house for questions from the audience and answers by the experts on the panel and chairpersons. I am sure the program of webinar laid out in the colorful flyer, which is available with you in soft form on your devices, will definitely elicit your interest enough to actively participate in this webinar and share your views and thoughts, discuss problems and challenges, find out solutions and ways how ultimately the mediation movements as part of ADR technique can give peace to the disputants in this quicker and most economical and smooth dispute resolution mechanism available worldwide. As you all know, with the advent of Commercial Courts Act 2015 in our country and mandatory mediation in a pre-litigation mode prescribed in Section 12, Capital A of the Act, and other enactments like consumer protection, family laws, etc., recognizes mediation as the most efficient mode of dispute resolution. We definitely need suitably trained large number of mediators in all these states and a continuous evaluation of performance of the mediators and their persuasion and guidance to the parties while guiding them through the process of mediation is also an equally important exercise. That is the reason why holding of such webinars was considered essential. As the virtual platform has come to stay for long now in our judicial institutions also, I wish this webinar a great success, and I welcome all the suggestions for further improving any aspect of this webinar or similar conferences from all corners. And as Swami Vivekananda said, let light come from all sides. I wish to be enlightened by all wise people, and I assure that I and my team in Gujarat State Legal Authority will leave no stone unturned to put the mediation movement in the state of Gujarat back on a higher pedestal for the larger public good. I once again thank Honorable Chief Justice, my brother and sister judges, all PDJs and members of the judicial fraternity in districts, member secretary, and his team in authority, the learned speakers, and all invited guests in the audience who have spared their valuable time and participated in this webinar. Thank you. Jai Hind.
Thank you very much, my lord, for your welcome address. Now may I introduce Honorable Chief Justice Vikram Nath Sahib. As you all know, words are not enough to introduce our Honorable Chief Justice, High Court of Gujarat, Sri Justice Vikram Nath Sahib. My lord was born on 24th September 1962. His lordship had done his graduation in science in the year 1983 and law in the year 1986. His lordship got enrolled as an advocate on 30th March 1987 and had practiced at Allahabad High Court. His lordship was elevated as additional judge on 24th September 2004 and appointed as Chief Justice of Gujarat High Court on 10th September 2019. I would like to request Honorable the Chief Justice of High Court of Gujarat and Patron-in-Chief of Gujarat State Legal Service Authority, Mr. Justice Vikram Nath Sahib, for his lordship inaugural address. Sir, please.
सभी लोगों को नमस्कार. A warm welcome to everyone on this Saturday morning. for this wonderful webinar organized by the Gujarat State Legal Services Authority. And with the topic, Mr. Project Officer, you may mute yourself. Yes. On a topic which actually requires a lot of deliberations and for the way forward, because the COVID movement has taken, pandemic has pulled us down very badly. The entire, what to say of nation, the entire world is at a back foot. So it's a very relevant topic for us to discuss as to how to re-energize mediation movement post-COVID 2019. Brother Dr. Justice Vineet Kothari, Executive Chairman of Gujarat State Legal Services Authority, my esteemed sister and brother judges, Mr. Mulia, Member Secretary of the Gujarat State Legal Services Authority, distinguished officers of my family of the Gujarat Judiciary, senior mediators, other mediators, learned speakers connected from all over the country. I'm told some teachers and students would also be joining and would be watching the program. You are also welcome, ladies and gentlemen. First of all, I would like to thank Brother Justice Kothari for inviting me and making me part of this valuable webinar on a very important subject of mediation, so dear to me otherwise. After leaving Allahabad, I have been little disassociated with mediation, but now that something keeps happening, I am also connected with it. At Allahabad, of course, I had a lot of opportunity to work in mediation, being there in the committee with Justice Sunil Ambani, who was the chairman for a very long time there. Friends, life is a continuous battle since the first heartbeat taken in mother's womb, the safest abode, up to the last breath of physical surrender before the Almighty. Man keeps fighting for his survival, and ultimately, only he succeeds who never gives up in any situation, howsoever grave. It is quite evident in the history that an army marches forward with a huge number of soldiers, but even after being victorious, the number of combatants has never remained the same. Many of the warriors embrace martyrdom during the battle. But if this fact doesn't affect the vehemence, the zeal of conquest, and the army eyes only the goal of triumph, nothing in this universe can refrain them from being victorious. Yes, COVID-19 has been the biggest enemy in the past 18 months. The whole mankind is struggling and fighting against in this battle with an invisible enemy. Millions of warriors have succumbed to death, and unfortunately, most of them untimely. But still, we can't take our eyes off the goal and can't stop creating the marching sound of our strong boots. True it is, COVID-19 has given major blows and left cracks on the mirror of hope, but still it has not shattered, nor we can afford it to be. We have to recollect our enthusiasm and passion to move forward and repair it with utmost care and caution, and in such a perfect manner that no cracks or scars remain visible. We should also not forget that the show must go on. So far as the movement of mediation is concerned, of course, we have lost so many of our warriors who had been putting in their untiring efforts to serve a noble cause of helping people and litigants to settle their disputes in an alternative way, comparatively free from legal technicalities, less expensive, and generating a win-win feeling. With sincere gratitude and salute to our departed warriors, let's move forward. The concept of mediation or alternate dispute resolution in India dates back to centuries before the British came to India. There used to be panchayats in villages comprising of elderly respected people as panchas, who in the presence of disputing parties would solve their disputes in an amicable manner. So far as the legal development is concerned, Legal Service Authority Act 1987 came into force with effect from November 1995, which gave formal codified recognition to the alternative measures of dispute redressal and gave a statutory status to Lok Adalats in India for the first time. Later in 1996, commercial mediation was given life when the Indian Parliament amended the Civil Procedure Code and introduced Section 89 with effect from sometime in 2002, I believe, which empowered courts to direct settlement of disputes by mediation amongst other means. May I take this opportunity to congratulate the Gujarat State Legal Service Authority under the dynamic and energetic leadership of Brother Justice Kothari, and also appreciate its endeavor of organizing this seminar, technically a webinar, in such stringent circumstances. It clearly reveals not only its professional devotion, but also its pious thought of serving the common man. As the head of state judiciary, I am quite sure that this technology assisted meet and various aspects of mediation going to be discussed in it will certainly help in developing a new, altered, and much needed mechanism in this post COVID situation, so that it takes forward the movement in an effective way. I have no doubt whatsoever that the topics so thoughtfully selected are going to be discussed throughout the webinar and will lead to an effective, concrete, and fruitful outcome. In these 2 days, our distinguished and learned speakers and participants will be throwing light on various aspects of mediation that will surely remove the dust particles of COVID, and the vision of effective and successful mediation will be more clear than ever before. As per the design program, I can see that in this webinar, we'll be focusing on the need of training of team workers at every level in order to enhance their capability to more efficaciously understand the psychology of the disputing parties, to find out the actual points of conflict, to bridge the gaps between the parties, provide them the options which can help them settle the disputes in a healthy manner and with no disappointments. We will also be dealing with the specific role of parties, mediators, lawyers, and judges in the mediation process, and also try to achieve some new ideas in order to brush up the capabilities of these stakeholders and to establish mediation as an emphatical measure of alternative dispute redressal. I would also like to specifically mention that technology has been playing a very important role in keeping us all connected. This online working procedure has facilitated right from the parties up to the judges to keep on doing our work by observing COVID norms. We should also try to think more about its optimum use to serve our purpose. In the end, I would like to once again congratulate the Gujarat State Legal Service Authority for organizing this webinar. I also extend my best wishes to one and all connected with this program. I am quite sure that this webinar, with its informative, creative, and interactive sessions, is going to be a great success. My best wishes are always there. As a senior most member of this big judicial family, I would like to assure you all that I am always available to listen to you and receive new ideas from all of you. Whatever needs to be done at my end will surely be done to the best of my ability and capability. I am looking forward to a very successful and fruitful webinar. My blessings and good wishes. Thank you.
Thank you, sir. Thank you. Grateful.
Thank you very much, my lord, for your splendid inaugural address and the words of wisdom, which will definitely enlighten the purpose of this webinar. Today, in this webinar, Sri Hiralal S. Patel, Chairman of Bar Council of Gujarat, is also amongst us as the guest. Sri Hiralal S. Patel, Chairman of Bar Council of Gujarat, was born at village Ramos, Taluka Modasa, district Sabarkantha, in the family of farmers, practicing since 43 years in legal profession in district and sessions court, and has served as president of Modasa Taluka Bar Association and Arvali District Bar Association for many years. Sri Hiralal S. Patel is serving as a member of Bar Council of Gujarat since last 3 terms. He has organized and also participated in many legal seminars. He rendered services as chairman in various committees of Bar Council of Gujarat. We extend our heartfelt thanks for spending your valuable time, sir. Now, I would like to request respected member secretary, sir, Gujarat State Legal Service Authority, Sri Muya sir, to propose the vote of thanks. Sir.
Namaste. Good morning to all the respected dignitaries and distinguished guests. I deem it a great pleasure in revealing my eternal gratitude to the Mediation Monitoring Committee for asking me to offer a vote of thanks. Thanks for this honor. A warm and cherished morning to our most valued and respected Chief Justice, High Court of Gujarat and Chairperson of Mediation Monitoring Committee, Honorable Mr. Justice Vikram Nath Sahab, the esteemed Executive Chairman of Gujarat State Legal Services Authority, and Member of Mediation Monitoring Committee, Honorable Dr. Justice Vinit Kothari Sahab, Honorable Judges of High Court of Gujarat, Brother and Sister Judges, Mr. Hiralal Patel, Chairman of Bar Council of Gujarat, Senior Mediators, Trained Mediators, panel lawyers, paralegal volunteers, stakeholders of the legal services institutions, professors and students of the law colleges, on behalf of the Gujarat State Legal Services Authority and Mediation Monitoring Committee, as well as the entire fraternity of the legal services institution, and also on behalf of all the judicial officers, my sincere thanks to my Lord Justice Vikram Nath Saab, Chief Justice, High Court of Gujarat and Chairperson of the Mediation Monitoring Committee. By His Lordship's blessings and grace, we are able to make this inaugural session what it was. Your Lordship's thought have enlightened our minds and shown us a new path for bringing home the repute which the state of Gujarat had for initiating mediation in the country. Lordships, thanks a lot for giving us your Lordship's precious time out of your Lordship's busy schedule. It really means a lot to us. Your Lordships have already added a charm to this inaugural session. Thank you, Lordship. Lordship, it was truly impossible without your Lordship's motivation to organize such an event. Your Lordship really motivated us to give our best. Thank you, Lordship, once again. My sincere thanks to Honorable Executive Chairman of the Gujarat State Legal Services Authority and member of Mediation Monitoring Committee, Honorable Dr. Justice Vinit Kothari Saab, who spent his busiest time gracing the occasion. Wholeheartedly, I must thank your Lordship for constant support, guidance for organizing this event. Thank you, Lordship, for assisting and encouraging all of us. Thank you, Lordship. A big thank you to Honorable Mr. Justice R.M. Chaya Saab, member of Mediation Monitoring Committee, for his Lordship's effort in granting permission to arrange this webinar. I mention my deepest sense of gratitude and would place on record my thanks to Honorable my Lord Justice R.M. Chaya Saab. My sincere thanks to all the Honorable Lordships who have graced this inaugural session. Thank you to all the Lordships. I also extend my gratitude to Mr. Hiralal Patel, Chairman Bar Council of Gujarat, for his gracious presence in this inaugural session. I want to extend my gracious thanks to Mr. Niranjan Bhatt, Mr. Paresh Jani, Mr. J.P. Singh, Ms. S. Susila, and Ms. Sadhana Ramachandran, senior trained mediators from Ahmedabad, Delhi, and Bangalore respectively, for their presence in inaugural session. I wish to extend my gratitude to Honorable Registrar General Saab and his team for extending all possible support. I also thank all the judicial officers who have participated in this webinar. Thank you to all. Thank you. Jai.
Thank you very much, Munia sir. Now we are entering into the mainstream of our program, and we will be starting our first technical session of webinar on the subject of mediation landscape in India, with reference to its development, challenges and opportunities. And we will also discuss the topic, why training in mediation. The first technical session will be chaired and co-chaired by Honorable Mr. Justice R.M. Chaya Sahib, Judge High Court of Gujarat and member Mediation Monitoring Committee, and Honorable Ms. Justice Sonia Gokani Madam, Judge High Court of Gujarat. Before starting the session, I would like to introduce Honorable Mr. Justice R.M. Chaya Sahib, Judge High Court of Gujarat. My Lord was born on 12th January 1961 at Verawal, district Junagadh. His Lordship did Bachelor of Commerce from MS University in year 1981 and had done LLB from L.A. Shah Law College, Ahmedabad. My Lord got enrolled as an advocate with Bar Council of Gujarat in 1984 and was empaneled advocate for many prestigious organizations in state of Gujarat. My Lord was appointed as Assistant Government Pleader and Additional Public Prosecutor in High Court of Gujarat in 1991. His Lordship was elevated as Additional Judge, High Court of Gujarat on 17 February 2011. Now, it's my proud privilege to introduce Honorable Ms. Justice Sonia Gokani Madam, Judge, High Court of Gujarat. Her Lordship was born on 26 February 1961 at Jamnagar and did BSc in Microbiology and did graduation and post-graduation in laws. As an advocate, her Lordship had worked with various organizations for the downtrodden, women and children, as also for upholding the cause of environment. Her Lordship had joined judiciary directly in the cadre of district judge as Judge City Civil Court, Ahmedabad, and on 10th July 1995, and presided over many famous and landmark civil and criminal matters. Her Lordship has presided over special courts under anti-terrorist laws and CBI court. Her Lordship had also served as Registrar Recruitment in High Court of Gujarat and also served as Registrar IT and Infrastructure. Her Lordship was elevated as Judge of High Court of Gujarat on 17 February 2011. The Speaker we will be taking here a short break before introducing our speakers of the first session. We will be joining back on the same link within 5 minutes.
Thank you, Lordship. Honorable Chief Justice Sahab, Honorable Executive Chairman Sahab, and Honorable Member of Mediation Monitoring Committee Justice Chaya Sahab. Thank you so much, sir. Thank you.
Thank you so much.
Thank you.
Namaskar. Thank you.
Namaste, Lordship.
Namaste, sir. With permission of my lord, we may start our first technical session. The speakers who will be enlightening us in the first session are Sri Niranjan Bhatt, Senior Mediator, Ahmedabad, and Sri J.P. Singh, Senior Mediator, Delhi. Before starting the session, I would also like to introduce the speaker of the session, Mr. Niranjan Bhatt, Senior Mediator. Mr. Niranjan Bhatt is practicing as an advocate in Gujarat for 63 years and have contested many civil litigations as a senior lawyer in Gujarat. Has also worked as Government's Counsel in Machu Dam Disaster Public Inquiry and Supreme Court appointed Commissioner's Counsel in Judges Abduction case. He is a senior mediator in India since 2001. He was a member of Supreme Court delegation to US Supreme Court led by Chief Justice of India. He took advanced mediation and negotiation training at Harvard Law School. He is a senior mediator trainer approved by MCPC Supreme Court of India. He has conducted mediation trainings in Gujarat, Delhi, Bombay, Bangalore, Allahabad, Lucknow, Punjab, and Haryana. He had practiced in international mediation conferences at USA, Austria, Australia, Germany, and Austria, and national mediation conferences at Delhi and Mumbai, Commonwealth Conference at Delhi, and Pound Conference at Chandigarh. I would also like to introduce our another speaker of this session, Mr. J.P. Singh, Senior Mediator, Delhi. He is a well-known civil, commercial, and arbitration lawyer. He is also an accomplished mediator. He is the founder organizing secretary of Samadhan, the Delhi High Court Mediation and Conciliation Center. He has received his training in India and also in USA, where he has undergone training of trainer program. He has been a part of training program for mediators held within India and abroad. He has been appointed by the Mediation and Conciliation Project Committee of the Supreme Court of India as an observer of several training programs. He is also the former Vice President of the Delhi High Court Bar Association. Now I request the Honorable Chair and Co-Chair to take over the session. Sirs, please.
Good morning, everybody. At the outset, I am obliged to my Lord's Justice Dr. Vinit Kothari for giving this opportunity to me. I personally believe that when we have learned speakers, as rightly pointed out by Justice Kothari, iconic figures with us, we should be short even in giving introduction to the two subjects which are earmarked for this first technical session. First subject, mediation landscape in India. I believe that it gives us a feeling of the history of mediation in India. Blake Law Dictionary has defined mediation, I quote, a method of non-binding dispute resolution involving a neutral third party who tries to help the disputing parties to reach a mutually agreeable solution. As pointed out by my Lords the Chief Justice, the movement of mediation we find in India in Panchayat, but I would go a little further. Wikipedia, if it is referred to, it says that even Samudra Manthan was one of the earliest form of mediation. We find mediation even in Ramayana and Mahabharata. The Indian Parliament also has recognized the concept of mediation since long. The concept of mediation one would find for the first time in the Industrial Dispute Act 1947. The conciliators appointed under Section 4 of the Act are charged with the duty of mediating in and promoting the settlement of industrial disputes. The Indian legislature made headway by enacting the Legal Services Authorities Act 1987, by constituting the National Legal Service Authority as a central authority with the Chief Justice of India as its patron-in-chief. The central authority has been vested with duties to perform, primary amongst which is to encourage the settlement of disputes by way of negotiations, arbitration, and conciliation. The Indian Parliament enacted the Arbitration and Conciliation Act in 1996, making elaborate provisions for conciliation of disputes arising out of legal relationship, whether contractual or not, and to all proceedings relating thereto. The Act provided for commencement of conciliation proceedings, appointment of conciliators, and assistance of suitable institution for the purpose of recommending the names of conciliators or even appointment of conciliators by such institution. Alternative dispute resolution is also found in a way in the CPC in section 89 with effect from 1st of July 2002. As per section 89(2) of CPC, where a dispute has been referred to Lok Adalat, the court shall refer the same to the Lok Adalat in accordance with the provisions of section 20 into bracket 1 of the Legal Service Authorities Act 1987. As one would find, the alternative dispute resolution is also found in other acts such as section 29(2) of the Special Marriage Act, section 18 of Micro, Small and Medium Enterprises Development Act 2006, section 442 of Companies Act 2013, section 32G of Real Estate RERA Act, and section 12A of the Commercial Court Act 2015. Even one would find such provisions in form of section 37 and 38 of chapter 5 of the Consumer Protection Act 2019. It is a matter of fact, as can be seen from the history available on mediation. The first elaborate training for mediators was conducted in Ahmedabad in the year 2000 by American trainers sent by Institute for Study and Development of Legal Systems. We are proud to have Niranjan Bhai today with us in the first session itself. I'm sure he was part of that training program as a trainer. Many feats have thereafter been achieved even through judicial precedents to ensure mandatory mediation through courts become a legal sanction. Today's both the subjects in the first session, as I repeat what I said earlier, is in line of even the precedents of the Supreme Court in the case of Efron and M.R. Krishnamurthy. We have with us two very eminent, iconic figures on both these subjects. I would request Sri Niranjan Bhai to give his literate opinion on both these subjects. Thank you very much again, sir.
Thank you, sir. May I, sir, begin?
Yes, please, sir.
Yes. Honorable Executive Chairman of Legal Services Authority, Dr. Vinit Kothari, sir, who has been instrumental in starting the effort to re-energize mediation in Gujarat. Justice Chaya has been also taking a lot of interest. And in fact, I remember before he became a judge, Supreme Court had appointed him as a mediator in a very complicated land acquisition matter. And he was successful in pleasing not only the agriculturists whose land were acquired, but also the acquiring body, brought them together. And at that stage of Supreme Court, he could settle that matter. I have also the experience of appearing before Justice Sonia Ben Gokani, and I'm glad that today we are all together. So far as Gujarat is concerned, Gujarat has started mediation in our country in 1999. We had organized a conference in 1998 where we discussed the delays in the court and its solution. And at that time, mediation was not so popular. So we had to convince people by keeping the subject, let us manage the unmanageable. And their idea of mediation originated. Now, India is such a vast country. There is diversity of culture, diversity of speeches, diversity of food habits. And therefore, in this country of our India, mediation is most suitable. And for that purpose, I would like to take you to a 5-minute DVD as to why I say that mediation is India. Let us see this wonderful DVD, which will explain to us the importance of mediation in our country.
India is the cradle of the human race, the birthplace of human speech, the mother of history, the grandmother of legend, great-grandmother of tradition, our most valuable and most restricted materials in the history of man, treasured in India. India, a land of a billion people. Of gods and goddesses, and of sages, saints, sadhus, and swamps. And while India is a land of multiple experiences, the one word that describes India best is diversity. 28 states, 7 union territories, 602 districts and rivers that run across many states. Diversity in geography. Diversity in languages. Over 1,600 languages and dialects. Currency printed in 15 languages. clothing. Diversity in food. Spices that appeal to different parts of the body. Spices so diverse that there simply are not enough English words and adjectives to describe their tastes and experiences. India is a land where thousands of communities coexist with their diverse and unique customs, rituals, movements, and festivals. And yet, ancient India still continues to live in the pages of history as the birthplace of science, mathematics, astronomy, and the hub of culture and philosophy. Ancient India. Two small words that invokes millions of images. Art, craft, heritage, history, festivities, celebrations, culture, peace, unity, friendship, synchronization, love, emotions, feelings, sentiments that now lie buried deep within after 200 years of the imperial rule. And while the whole world is today talking about mediation, conciliation, and arbitration, it's time to rediscover the origin of these words. It's time for us to explore the timeless principles. It's time to relive ancient India, the creator of win-win situations. Mediation is all about wisdom. Mediation is all about reason. Mediation is all about prudence. Mediation is about India.
So, friends, mediation is about India. It was said when mediation was talked about in India that mediation is of a foreign country. But I want to establish that mediation originated in India. If you want to understand any concept of law or procedure, we have to understand how mediation developed all over the world. It was in Stone Age that solution was by might is right. Then came ancient India, Vedic times, 4000 to 1000 BC. Vedic hymns were written saying about how the world is full of cooperation and brotherhood. Then early Aryans were vigorous people, unsophisticated people, and they believed in divine wisdom, the wisdom prevailing in heaven and earth. That was the divine wisdom, reason, and prudence. So origin words of mediation are wisdom, reason, and prudence. On these three words is structured the whole process of mediation, and Western countries have also accepted that these three words are the origin of mediation in the world. So then came Rishi Yajnavalkya, who was the first mediator in the world. He believed in settling the matters by cooperation and participatory method. If we study mediation today, participation is the crux of it, and it originated in the times of Rishi Yagnavalkya. He has set up 3 mediation centers at different places in India. First was Kula, where all family disputes were settled, all neighborhood disputes were settled, and caste disputes were also settled. Then another mediation center was Shreni. Shreni held mediation centers for artisans and those who were concerned with producing objects or producing different articles. And the third was Puga, where traders used to go for settling their dispute. Then learned Buddha also propounded mediation in his wisdom and in his religious speeches. He said, know well what will lead you further, and know what holds you back. So the principles of modern mediation is future. Look at future and not at the past. They were originated by Lord Buddha in his speeches. Then jurist Patanjali also said that don't think of what is right and wrong. Share and cooperate. These are also the principle of modern mediation. In days of Mughal kingdom, there were 2 courts. King's court, which decided what is right and what is wrong. And there was mediator's court, which was conducted by Birbal. And therefore I say that whenever the solution is found by an indirect method, by a method by which you refer outside the box, and that was the principle propounded by Birbal. And that is also today a fundamental principle of mediation accepted all over the world. Then came the growth of industry, commerce all over the world. At that time in USA, there was a lot of congestion of work. Lawyers were charging very high fees. And at that time, in Nebraska University, there was Mr. Pound, the leader of that university, who called a Pound conference. And in this Pound conference, different subjects were discussed, how justice can be expedited. And he started proposing that there should be in-between persons, learned people, trained people who should help party in themselves deciding their disputes. These are also fundamental principles of mediation. Then came Frank Anders of Harvard Law School, and he said there should be multi-door courthouse. In one door, you can go for deciding your disputes in a court of law where rights and wrongs are decided. There is another door where mediation was provided. There is a third door where arbitration was provided. There was a fourth door where judicial settlements were canvassed. Therefore, sir, in this is a legal history of mediation. Then in 1947 came Industrial Disputes Act, about which Justice Chaya has already talked. Then 1987 was Legal Services Act, which propounded Lok Adalat in our country. Then there was also Civil Procedure Code. In 1940, when Arbitration Act was introduced, Section 89, which provided for arbitration, was repealed. Then in 1999, Civil Procedure Code was amended. When Civil Procedure Code was amended, there was a kind of congestion of cases in the court. Let us say under what circumstances. In 1999, 89 was introduced. Yes, Mitali? See, litigants are consumers of justice system, they must give opinions to give options to litigants. So it happened that there was a lot of inflow of cases and outflow was very less, because the detailed system of court used to do a lot of justice. And for doing justice, the entire Anglo-Saxon law which was introduced in India had to be followed. And therefore, there were more inflow of cases, outflow was less, because there was a traffic jam in court of law. At that time, the parliament, Indian parliament, thought of finding out the ways out. And that time, Section 89 was amended. And if you look at Section 89, read Section 89, we will not understand its purpose as much as we would see it by our visually we see them. Let us see how Section 89 provided for different alternatives. Some cases can go to arbitration, some deserving cases can go to mediation, some other cases can go to Lok Adalat. There was also provided for conciliation, and therefore trial was left with those cases where judges would be more comfortable in deciding the cases, so that they can concentrate on such disputed cases if he can be relieved of a lot of work burden, and they can do better justice, more quick justice in the cases which go to the court of law. Friends, then in 1998, for the first time, Ahmedabad Bar Association and a trust formulated by two lawyers of Ahmedabad, a public trust was created by name Institute for Arbitration, Mediation and Legal Education. And in 1988, this conference was held in which the idea of mediation was discussed at length. Lawyers were not very conversant with what mediation is. Mostly people thought that when a senior lawyer is asked to settle the dispute, he would give his proposal and convince the party. But mediation is more global. After global introduction to the theory of mediation, a lot of improvements have been made. A lot of new ideas are brought into mediation, and therefore MLEAD and Ahmedabad Bar Association and Gujarat Law Society organized this mediation conference. Thereafter, it was in 2002, January 27, first lawyer-run mediation center by Ahmedabad Bar Association was inaugurated by Justice B.N. Kirpal on 27th July 2002. A private trust offered their place for running this mediation, and mediation started, first idea of it. Later on, when court annex mediation was introduced, this mediation center stopped its activities because more people wanted to go in court annex mediation. The judges also supported it, law also supported it, and the mediation centers were opened first in Chennai, which was the first mediation center, then in Delhi, and then in Karnataka, and then in Gujarat also, and then one by one in all courts of India. The mediation centers were opened, court annex mediation. Now, court annex mediation gradually gained popularity, and therefore, friends, many cases are referred to court for mediation. There, judges, lawyers, and clients, all the three make a different partnership. And by that partnership, people learn how to agree to a settlement. Settlement is more important. The people started having idea that right or wrong is not as much important as interest of the parties, their concerns, how they can get what they want in an expeditious manner. Therefore, gradually, mediation is gaining momentum in our country. Then it happened that MCPC Mediation and Conciliation Committee of our Supreme Court took a tremendous interest, and they formed a committee of the Supreme Court judges, and they promoted mediation. It was the first time, because in foreign countries, mediation was commenced by community. In India, mediation was commenced by the courts, and therefore people had more confidence in it. Judge used to supervise it, and therefore mediation idea has now come in. And as Justice Chhaya sir said earlier, that one by one acts are being amended. There are 17 acts today which provide for pre-litigation mediation also. And therefore, question before us is, what are the challenges to us? The first challenge is that we have many litigants who should be imbibe the idea of settling the disputes, retaining with them the decision-making power. Therefore, to popularize mediation, we'll have to convince the people at large that, look, here is a place where you can go, you yourself can participate. In Anglo-Saxon law, the Civil Procedure Code, which was imbibed from British rule, they don't get opportunity themselves to represent their case, to speak. They would only ask that speak what is asked. Whereas in mediation, litigants can themselves participate. So it's a party-oriented procedure that we have to get established in our country first. So that is our first challenge. Our second challenge is that lawyers are accustomed to go to the court to fight litigation for their clients. Their going to the court increases the dispute further. Conflict arises further because they go there to fight. And the lawyers are very faithful to their clients. So they represent them in a most able manner. Our judicial system also is an excellent system, established all over the world, that Indian judicial system is excellent. Therefore, we have now to think about lawyers also trying to, instead of arguing the case, they will have to develop mediation advocacy. In mediation advocacy, they look at the interest of the parties, the interest of the opponents, interest of their own clients. Unless you share the dispute, unless you give something to the other person, agree to give something to the other person, they can't give anything to you. So it's a give and take method. For that, lawyers will have to be ready now to understand what mediation is, how mediation case can be represented, how they can advise their client that mediation is in their interest. Then also another thing, lawyers are said to be the best mediators. And if they become mediators, they will be better mediators. And therefore, they will also to now learn mediation. Therefore, this challenge is to train mediators in India. And for that, we'll have to establish various training centers all over the country. We'll have to provide mediation training to some people who can be mediation trainers. So Supreme Court, MCPC has been organizing training to trainers. So training to trainers, lawyers will have to feel passionate about mediation. This is another challenge. Third challenge is our judges will have to understand how to refer cases to mediation. They will have to find out from basic study of every case, which cases are suitable for mediation. In a later part of this seminar, we are going to discuss how judges can refer the cases to mediation. I'm very happy to note that in Karnataka and in Delhi High Court, there is a mediation board, and almost every day, about 80 to 100 cases are referred to mediation by judges. And their judges also participate, because judges are the primary originators of mediation, because they refer the mediation to mediation center. And therefore, judges also will have to face a challenge of understanding which are the cases suitable to mediation, which are the cases suitable to arbitration, which are the cases suitable to lok adalat, and which are the cases suitable to conciliation or judicial settlement. That is one challenge before our judges. It is said that judges in US Supreme Court and US High Courts also go to study mediation because there are two aspects of it. Their burden is lessened if matters go to mediation. Therefore, it's a combination of devotion by judges, devotion by lawyers, and devotion by litigants. That is one challenge. Then the last challenge is we will have to provide for mediation centers. Sooner, very soon, an exclusive mediation law is in the offing. It is pending. Supreme Court had formed a committee to draft that law. It is drafted and it is submitted. Therefore, friends, now, before I end these challenges and opportunities for lawyers to have a new profession, I want to, in the end, read before you a nice poem on mediation. बोलता है, ध्यान से सुनो, बात को गुनो, छोड़ो पूर्वाग्रह, सत्व को चुनो, रहो निष्पक्ष, जब दोनों ही पक्ष करे स्वीकार, तब मध्यस्थी बनो, वो ही प्रयास, जीतो विश्वास, दूर खड़े प्रतिपति आए पास पास, मिटेंगे व्यय और विलंब, मीडिएशन समाधान निकले अविलंब, दोनों की जीत न कोई हार, हाल हो स्वीकार, कुशल मध्यस्थी की क्षमता अपार, देर दौड़ भाग बड़ी निराशा है, मीडिएशन एकमात्र कल की आशा है, मीडिएशन की अलख भारत में जगी है, सत्य वकील असील और जजेस भी लगे हैं, जगाया उन्होंने जन में विश्वास, दिन प्रतिदिन सफल प्रयास, न्यायाधीश अधिवक्ता सबके बड़े हाथ, मीडिएशन का बैनर खड़े साथ साथ. Ladies and gentlemen, in this short speech, I wanted to introduce to you mediation in our country to all. Thank you very much.
Thank you, sir, for enlightening us with your expertise on the subject. I entirely agree. Recently, the Honorable Apex Court in the case of M.R. Krishnamurthy versus New India Assurance reported in 2019 SCC online page 315, while considering a plea seeking reforming Motor Vehicle Act claim system, has asked the government to consider the feasibility of enacting the Indian Mediation Act to take care of various aspects of mediation in general, and issued several directions to the government. And as you rightly pointed out, it is at the stage of draft. I now invite the other respected and learned speaker, Mr. J.P. Singh, to enlighten the August gathering. Mr. J.P. Singh, please.
Thank you so much, sir. Thank you, Niranjan Bhai. You know, we refer to Niranjan Bhai as the Bhishma Pitama of the mediation movement in India. You know, Niranjan Bhai was the person who helped us to embark on this beautiful journey of mediation. He was amongst the first trainers who trained lawyers in Delhi. See, as was even in US, when the movement started, lawyers were up in arms because lawyers thought, in case all matters get resolved, what will happen to their practice? You know, ADR was seen as mediation. ADR was seen as alarming drop in revenue. And Niranjan Bhai, in those circumstances, came to Delhi. We got trained and we have not looked back. Well, question is, why do we need training in mediation? Goal of any training in mediation is to acquire core skills in dispute resolution. And when we talk of skills, what is important to be seen is how do we acquire these skills? And if you look at, the first aspect, let me explain this to you with an example. I remember as a child when I was given the first bicycle, and all of you must have tried to ride a bicycle in the childhood. Nowadays you get those smaller versions for children, but so far as we are concerned, I had the full bicycle to ride. Now, this bicycle is given to us to ride. We don't know how to sit on the cycle. I couldn't even reach the seat. And therefore, what was that stage in every skill when you want to acquire? The first stage in every acquisition of skill is unconscious incompetence. You are not conscious of the skills required to ride the bicycle, and you are also incompetent. Because, without knowing the skills, how do you ride the cycle? Then comes the next stage. Now, what is the next stage? You are told how to ride the bicycle. Put your feet across, start balancing the bicycle. And that is the stage when you try and balance and you fall. The stage that you reach is now you've been made aware of the skills, but you are incompetent. So your stage now is conscious incompetence. So first was unconscious incompetence. You did not know what skills were required to ride the cycle. Then you were told, well, this is how you balance yourself. You tried and you fell. And so many times we hurt ourselves. And therefore you reach the stage of conscious incompetence. Now comes the next stage. I remember I started slowly started balancing on the bicycle and was talking to the air. Was so thrilled that you could put your feet across through the bar and start riding the bicycle. And in fact, when I would sit on the seat, my feet couldn't even reach the pedal. So, but at least now I could ride the bicycle. So what was my stage? Conscious competence. Now, consciously applying those skills, I could ride the bicycle. So I had reached that stage. Then comes the next stage. Now, what is the next stage when we acquire this skill? Is unconscious competence. Now, when I want to ride a bicycle, I don't have to think. I don't have to apply my mind. I simply take out the bicycle and start riding it. So I have now, by unconscious effort, required the competence to ride a bicycle. Now, this tells you when you want to acquire the skills, you have to go through the stages of unconscious incompetence. Then you come to the stage of conscious incompetence. Then you become conscious competent. And then you start using those skills without even thinking about it. Now, this is what is the main purpose of training. Now, mediation is something, you may find it new, but the medical profession. So any person who's, an MBBS, do you think he starts performing surgery? No. He acquires MS. Then he starts practicing smaller operations before he gets into complicated surgery. So, therefore, to become a surgeon, you need to now acquire skills of how to perform surgery. So do you think you can start, mediating without knowing what mediation is? without being given the training. And this is the whole purpose. We have now, a training worldwide has been designed, which is about 40 to 45 hours, within which you get the first training in mediation. This training actually puts you onto the road of mediation. This is the threshold which is required to start into the journey of mediation. Now, Bar Council of India, in fact, has provided for a 45-hour course in mediation training for the college, the law students. Something which they believe in catching young. Abroad even talks of peer mediation. But so far as India is concerned, it started, Niranjan Bhai has taken us through that journey. It started as a court-annexed mediation movement. And when we talk of court-annexed mediation movement, what are we dealing with? We are dealing with adults. Now, when you deal with adults, there must be, and for an adult to learn or understand, they must, first of all, they must go through the process of learning. And they must be willing to learn. Once you are willing to learn, the adult learns best by performing, doing and performing. And these mediation training that has been designed, we have several role plays. So whatever theory that you learn is now being put into practice, because you will enact those role plays, and that theory which was explained to you, you will be doing it in practice. Now, what is ultimately, again, as I said, when we deal with adult training, what are the stages of this training it takes you through? Now, let me tell you about adult learning. There are 5 steps that are required. The first step is participation. Niranjan Bhai talked about it. You need to participate. And you must experience it yourself only if you participate into the mediation training. So first important thing is you must be willing to learn and you must participate in the training process. Then there must be repetition. See, because by doing once, you are not going to learn. I mean, the cycle example, you go on trying till you are able to ride the cycle on the saddle. So therefore, you need to repeat, and in these trainings that you will go through, the trainings that we design, you have several role plays on several aspects. You will be enacting those role plays repetitively, and more, as I said, it is experiential learning. And once you practice those role plays, you will understand how it is relevant, for you, because these skills that we are talking about, we call them life skills. Something which are relevant. Conflict is today a part of life. It is a reality. All of us go through the process of conflict and conflict resolution. Therefore, if you acquire these skills, because mediation is all about dispute resolution, and therefore these skills will help you. They will be relevant to you in your daily life. You will be using those skills. What are those skills? We'll talk about them a little later. So these skills you will require, whichever you acquire in mediation training, would be important for you for purposes of daily life. Then you should be able to transfer what you learn in training to real life. And I've already told you, once we call them real skills, you can carry it to your workplace. You can carry these skills home. Every day, whenever you are dealing with your children, whenever you are dealing with your spouse, what are you, there will be issues of conflict. We will be in conflict of what dinner do we want to have, what breakfast should be cooked today, which movie should we go for, should we buy this car or not, should we go for this holiday. All these are issues which you need to deal with. And therefore, you transfer what you learn in these trainings to the real life scenario. So therefore, for adult learning, you must participate, there must be repetition, it must be relevant to you, and you should be able to transfer it to your real life. Then comes the issue of feedback. You know, when we do these role plays, these mediation training role plays, we do coaching and mentoring along with it. So therefore, you can come to know where you are going wrong, what do you need to improve, how do you take the whole mediation process forward. All that will happen during this training. So it's unlike, you know, what happens in a school where a teacher is standing in front of the class and lecturing, telling the students. No, this is not what we do in training. In training, we involve you. We involve you into the practical aspect of whatever theory is being taught to you. And that's the only way you can acquire these skills. Now, having said that, Niranjan Bhai said this is an idea. He's already told you the challenges that we are going to face and the opportunities that are available. Mediation is an idea whose time has come. I mean, the courts are recognizing it. 89 was amended. And in fact, after 89 was amended, that actually mediation took off in India after Salem Bar Association case. And AFCON's case has already been talked about. AFCON's case actually told us what kind of cases can be mediated, what kind of cases cannot be mediated. But importantly, there was a, later on a judgment where Justice Arijit Prasad, then Supreme Court judge, he said, time has come for us to ask not what is the case, this case is whether it is appropriate, but a time has come to ask why this case is not appropriate. In fact, every case wherever relationship is involved is today capable of being mediated, and they need not land up in court. Now, I am asked also to tell you about our journey in Delhi, how the whole mediation center, Niranjan Bhai talked about the Delhi High Court Mediation Center. I told you bar was up in arms when the mediation movement started in Delhi. The mediation center set up in district courts was already vandalized. Our then Chief Justice, Justice Karju, said that he wants to set up a mediation center in the Delhi High Court. And we told him only one way we will agree, in case the bar runs it. To involve, you see, it was important, it's a court annex mediation center. So we need the support of the court, we need the support of the bar. Unless the bar participates, it was not possible to have the mediation center up and going. So we told our Chief Justice, only if the bar runs it, then it may be possible to set up the mediation center. We took up the challenge. Justice Karju agreed. He said the judges have their hands full because of the pendency of cases. And that is where I then was the vice president, was made the first organizing secretary of the center. We hid from the bar and took our first training because bar was hostile. But when we came back to the bar and told them that what a good scientific process this was, the bar was interested. And the journey in Delhi High Court started in 2 rooms. Now, Niranjan Bhai has also talked about the infrastructure, a challenge to infrastructure. We started in 2 rooms. And today we have 32 rooms, all state of the art. We have, from the court support stenographers. There's a pantry. Unlike court, you're served tea and water. Then there are psychologists which are attached to the mediation center. We have court staff which is transferred to the mediation center to assist us in day-to-day functioning. Then what is most important, court timings are from 10 to 5. But when it comes to the mediation center, we have sometimes kept the mediation center open till midnight because the mediation center would go on, because the sessions were going on and we were permitted to go on with those sessions. And sometimes in one of the cases, I certainly remember, a settlement was signed at midnight and the date has to be changed because it was after 12 o'clock. Then, unlike court where we wait for the honorable judges to arrive, in mediation, the mediator waits for the parties to arrive. So the whole mindset, everything was, totally required to be different. And mediators, especially the first few who got trained, took it up as a challenge, and it was, we never looked back. And today we have more than 400, anytime that your training is announced, you have more than 400 people who apply, and we can take only about 50. Now we have to choose. It's the residential program that we do. So there's a training. So when I talked about it is only a threshold, the 40-hour training only puts you on the road. Then we have an advanced training. Then we have a refresher training. When we do an advanced training, you are first put with a mediator, experienced mediator, to mediate matters. After you do 10 successful mediations, we give you a refresher. And so that to know that whether your fundamentals are clear, and then you start mediating on your own. So therefore, it's the training is, without the training, I don't think it is possible. Like as I said, a surgeon cannot perform surgery. You cannot do mediations unless you are trained, unless your mindset changes. Because mediation, the adversarial setup, what we are used to in court, we treat the court setup as a contest. We want to win cases. But when Niranjan Bhai said, when we talk of settlements, we look at interests of both the sides. And those settlements, we call them win-win. Both sides win because they get what they want. Now, to run the mediation center, we needed financial support. Now, in the beginning, we did not have the money to do it. How did we first do it? Then again, here comes the role of the judiciary. Costs which were imposed in matters were marked to the mediation center. And we created a corpus of nearly 50 lakhs, which ultimately helped us to pay the honorarium of the mediators. So therefore, first it began as costs being imposed and put in the mediation center fund, which helped us to run the mediation center. Then we got government grant. In fact, today in the Delhi High Court budget, there is a separate budget for the mediation center. As I told you, we have 32 rooms. I mean, state-of-the-art rooms. We have the staff there. There are about 250 odd mediators on the panel who are active, and their honorarium needs to be paid. And so therefore, all this now has become a part of the government grant, which is part of the infrastructure is so important. Niranjan Bhai talked about the next, you will have to set up mediation centers. And this is exactly what happened. From those 2 rooms, we have now 2 floors in the Delhi High Court. And every day, as was pointed out, there are about 80 to 100 matters which are fixed before the mediation center. Every day referrals are, I remember today, the last statistics I saw, there were more than 27,000 cases which were referred in the last 15 years to the mediation center. So it amounts to about 10, working days, if I see, about 10 matters every day were being referred to the mediation center. So unless there are referrals by the court, no mediation center can work. And our experience today, almost all the experienced mediators have mediated in more than 400 cases. And that has been our experience. And today, if you say the mediation center is doing very well, let me tell you, more than 60 to 68% matters are getting resolved in the Delhi High Court. And also, if you see the American US center where you talked of, Niranjan Bhai talked of multi-door court system, 95% matters get resolved before they go to trial. There are 5% matters only which go to trial. So therefore, this is, mediation is a movement which is here to stay, and it is very effective. So we got support from the bar. Ultimately, we got support from the government, and we got support from the court. That is how the mediation center in Delhi High Court took off. Then question was of litigants' awareness. So we have organized several programs where parties were made aware. There is a DVD which is being played all the time in the court's rooms. So when parties are waiting for their court matters or in the mediation center, that they can see the DVD being played, which tells them about what mediation is, what are the kind of matters which can be mediated, what are the results in those mediated matters, how the mediation is performed, what is the process. All that is being played. And when they are waiting for their matters, they're looking at it. We came to a state where matters now started getting referred by lawyers and parties at the pre-litigation stage. we have reached a position where instead of filing a matter in court, parties and lawyers request the center, please take up this matter at the pre-litigation stage. And those matters are getting resolved. Why are those matters getting resolved? Because parties, once they file petition in court, the situation, their positions harden. There is no face saving. If I made allegations against the other side, when it files a written statement or response to the petition, he will make further allegations. And the result will be the relationship will get sour, more sour. And it will be impossible thereafter to retreat because there will be no face saving. And therefore, we found at the pre-litigation stage, the results were much better than the matters which were pending in court. Because especially at the High Court level, in the, when a matter comes to the High Court level, at the district court level, somebody has won or somebody has lost. And therefore, once you are in appeal, a person who has won, thinks that now he has a great case, not realizing we have cases where they can be upturned in appeal. Then you have Supreme Court. I mean, I know of cases which we won in the first, before the single judge, before the division bench, and we lost in the Supreme Court. So you are never certain about litigation. Mediation gives you an opportunity to actually, be in control of the process, be in control of the outcome, and then get a judgment what you want, because that settlement will go back to the court and will get the stamp of the court. It becomes an order of the court. It becomes a decree of the court. And having said that, this has been actually our journey. This is why today, if the Delhi High Court Mediation Center, we have dedicated mediators. There's a change in mindset. When we are in court, we are litigative. But when we come and sit in mediation, our whole approach is different. Because mediation is not about winning a contest, as I told you. Mediation is about meeting the interests of both the sides. And therefore, it has worked. It is here to stay. And in case if it is used wisely, I'm sure, so far as Gujarat model is concerned, in fact, it has been told to you, the mediation movement actually started in Gujarat. But unfortunately, somewhere it fell down the line. What we need to do is, and it was the webinar has been rightly, called to re-energize it, to re-energize the system. And we call you to be a part of this journey. The litigants, the students who will be ultimately mediating in future. We also have the concept of peer mediation. We have been doing training of lawyers and law students in law schools. So therefore, students are the future. Lawyers need not worry, because if a matter gets resolved, the party will come to you with 4 more cases and say, this is a good lawyer. He got my matter resolved at the earliest. The party saves costs. The party saves time. Why would he not come back to you for more work? And therefore, and plus, of course, you will be appearing before the mediators. That's another opportunity as a profession. You will be acting as mediators. That's another opportunity of, Niranjan Bhai has already talked about. And so therefore, there are actually, opportunities galore. And it's only a question of time. And I'm sure Gujarat model will be replicated everywhere in India in future. Thank you so much.
Questions? Any questions?
Mr. Singh, for enlightening us both on aspect of training as well as the need of. I'm told that the question and answer would be in the last session. Therefore, I'm now.
Because we have 15 more minutes for this session.
Yes, but Ms. Gokani, Justice Gokani will have to.
Please.
I invite respected sister, Ms. Justice Sonia Gokani, to address the August gathering, please.
Thank you, brother. If anyone still wishes to just ask a question, they can do that. We can have it for 5 minutes. Brother Justice Chaya says that at the end it's going to be there. But if you feel that this is something, there is an urge to ask any question, the participant can do that for about
We still have 5-7 minutes. That's what
Yes, 5 to 7 minutes you can still ask, and then I'll conclude the session. Would anybody want to ask? Please raise your finger, yes, there is somebody. You can see the raising of the hand. It's somebody from Metropolitan Magistrate is wanting to ask something. All right. Maybe at the end of it, all of you can just think of it. Respected seniors and dear friends, we've been hearing the very scholarly and insightful, as well as the penetrative versions of the landscape of India from both the learned speakers, Shri Niranjan Bhatt and Shri J.P. Singh. We are thankful that they could spare the time and be with us. As Mr. Singh said, my journey, I would say, with the mediation has started with introduction and the guidance of Shri Niranjan Bhatt, a very senior lawyer and respected lawyer at City Civil and Sessions Court. They started way back in the year 2000, and all of us participated. When it came to the training had come from the center at USA. I think the Central Study Team from San Francisco had come. This is the Institute for Study and Development of Legal System. They had come and we had been trained. It had been quite enlightening, but yes, thereafter, we had been referring the matters to the mediators, and there were wonderful results also. The movement could not pick up so well as was expected, maybe in some last few years, but distinctly remember as a judge, City Sessions Court also, and thereafter in the High Court, that many of the matters have been referred to and wonderful results have come. They have taken us through this journey, which is a quite detailed journey. Why is this topic so much necessary? As all the speakers have said, personally, I feel that this is the right time to re-energize the movement of mediation. My gratitude to the Executive Chairman, Dr. Justice Kothari, for allowing me to be here. This is again a topic which is so dear to the heart. And I would always say that this was the right time, as King Ashoka could do it, and he started this peace movement after the Kalinga War. And it is this battle of ours with the fight with the unknown enemy of humanity, the COVID-19 virus as we call it. And we have now started thinking differently, having lost the dear ones, the friends, and the close family members, and seeing this dance of death around. We also realized as to how important it is to come out of the conflict, because as you know, the ambitions, competitions, conflict, aggressions, exploitations, violence, everything is an integral part of human life. The one sea of, the sea wave of the conflict that would come, and we would think that it would go away. And then you realize that no, there is another which is in the awaiting. So at that stage, what do? Do you take it as a conflict, as something, which one needs to be scared of? No, it is a challenge which one needs to take. It is as rightly pointed out by both the learned speakers who have so much of conviction for this cause of mediation, that you need to really change the mindset, which is so beautifully said, that unless we have a change of mindset as the judicial officers, we cannot internalize it. Anything that you need to internalize, which also, as Mr. Singh rightly pointed out, would be reflecting in your relationship with your family, with your friends, could be if you have a strong conviction for something, what you need to do. And life is what? It is relationship, as rightly being pointed out, and every relationship is bound to bring some kind of questions, conflict, competition, problems, questions. And every time when you need to deal with it, you will need to see as to how do you do it. So this is the best time for us to learn that and to mediate. So mediation training is not only going to help us in discharging our duties wonderfully, but also in our living life beautifully, peacefully. So therefore, it is very, very true that every case you mediate, every act you do as a judicial officer is going to then have impact on your personal journey of life, and that is going to be then made very beautiful. Now, we have been told that we need to have challenges, and this today's session we are talking about the challenges. So it is the party oriented process where they said there are many litigants, as Niranjan Bhai has pointed out, the lawyers and the judges, and then the infrastructure of the mediation center, etc. But the first and the foremost, in my opinion, is the change of the mediation. Now, change of the mindset. Now, if we look at it, why is there a need? Unless we are convinced about the need for the mediation or the matters to go to the mediation, we cannot do anything. And why this conviction? Why should we have this conviction? We'll ask the question to ourselves. The reason is that we know that everyone, the world flourishes in peace. The world or any relationship also will have a blossom only if there is a peace around. So you bringing peace to the any of the issues. So therefore, this is so much required. Now, there are 5 aspects we've been told: the cooperation, conciliation or the peace through conciliation, neutrality, detachment, awareness, and owning the responsibility. So these are some of the things which will be also convincing us, because in our process, there is some, of course, it is a statutory process. People have been respecting whatever we have been doing. But at the same time, if we look at it dispassionately, this process will bring us the neutrality, the detachment, and there will be an awareness amongst the people. So as I would take a liberty of saying in Gujarati, the speakers may pardon me, but which says, Jani, Joy, Samji, Vichari, Nenna Gamadwano Hak. So be aware of as to what you're doing, and then if you do not want to do it, it is your responsibility, and you also own the responsibility of your own decisions. So the parties feel this, they are participating, and then they can also, which can culminate into this. We are all committed to learn more as judges, and we are sure that the Legal Service Authority will take care of creating awareness amongst the litigants. The best part or best thing, which is so much I would like to emphasize at the end, is that the pre-litigation stage, what Mr. Singh has spoken about, and resolution at that stage, that is a wonderful thing. And I think more and more awareness needs to be created along that line. Parties, if need to keep the harmony, then in that case, without coming it to the court with litigation, they should be going for this mediation through the pre-litigation stage, and that can be then later on converted into the decree of the court. So that also is a provision in the legal service authorities, as all of us are aware, that anything that is done at pre-litigation stage could be later on converted into the decree. So since this process is something where sometimes, the mediators may get little frustrated that after so much of efforts, there is no solution, because the parties then choose not to, because they have a liberty not to decide finally. But at the same time, there our detachment comes, there our neutrality comes, and which tells us that it is for them to decide and let them own the responsibility. With that, I would say that's a beautiful journey we have started today, that life, and I would end it with the words of Vimala Thakar, a pragmatic spiritualist, who says, life is for living, and to live is to be related, to be capable of receiving the action of energies upon us, to interact with these energies. Living is harmonizing the energies. If there is disorder, if there is chaos or anarchy, then living becomes impossible. It is order and orderliness that results in peace. It is harmony that allows the energy of love to become activated amongst human beings, individually and collectively. So let us hope that at the time when we are talking about re-energizing the mediation movement, that this human energies or harmonizing the energy of love will take us and change the entire scenario. Because if the Delhi High Court says that it could, of course, end its matter, 60 to 68% referred matter could end beautifully. And if US can do it, 95%, we, as Niranjan Bhai has taken us to a beautiful journey of landscape of India, where we are the pioneers, in the world. Why can't we do it? With that commitment, we start this. Thank you very much. We are at the bottom of the heart, would thank on behalf of myself and the chairman, my brother Justice Chaya, for this wonderful, insightful, penetrative lecture and the discourses from both the speakers. Thank you very much, Dr. Justice Kothari, for giving me the opportunity to express myself. Thank you.
Thank you very much, my lord, and the speakers for guiding us, as well as the participants for attending the session. Now, we shall have a short break till 12 noon, and we'll gather back soon on this same link. Thank you very much.
Thank you.
Thank you, Brother Chaya. We'll take a leave.
Thank you for wonderful explanation, madam.
Thank you very much. Thank you, Niranjan Bhai.
Thank you, sir.
Sir. Hello. આવે છે અવાજ? વિડીયો બનાવો. હા.
Mr. Mulya, sir? Mr.
जी
Mulya,
मैम,
sir?
जी मैम,
So this
जी
is
मैम,
being
यस मैम.
during the course of my session, that is the first part will be taken by Mrs. Sadhana Madam Ji. Then I'll take the next session. In that, probably you may have to unmute Mr. JP Singh also, because at one particular point of time, he will also have to step in. So I request that you make me co-host, and then because we have to share the screen.
Then you are not audible. Your voice is not clear, ma'am. I could not get what you did. Could you please repeat, ma'am?
I request you during my session,
Yes, ma'am.
I have to share the screen. So probably you may have to make me a co-host. That's one
Yes,
thing.
ma'am. You are co-host already. Yes.
Then Mr. JP Singh may also have to be there, because he will step in my session for 2 minutes time.
All right. So you want me to co-host JP Singh sir?
Because he will be speaking in between. That's why.
All right. Sure.
Thank you.
I am also a co-host, Mulya sir. I am.
Ma'am, all the speakers are co-hosts, ma'am. All the speakers.
Good.
All are co-hosts, ma'am. Yes. So, with the permission of Honorable Justice J.B. Paladiwala Sahab and Honorable Dr. Justice A.C. Joshi Sahab, may I request the Masters of Ceremony to start the session.
Shall we start, sir, my lord?
Yes, please.
Welcome back, everyone, after a short break. Now we are moving towards the next session. In the second technical session, we are going to deliberate on conflict in the context of mediation, which will be chaired and co-chaired by Honorable Mr. Justice Paladiwala Sahib, Judge High Court of Gujarat, and Chairman High Court Legal Service Committee, and Dr. Justice A.C. Joshi Sahib, Judge High Court of Gujarat. Before starting the session, I would like to give introduction of Honorable Mr. Justice Paladiwala Sahib, Judge High Court of Gujarat. His Lordship was born on 12th August 1965 at Mumbai, completed graduation from JP Arts College, Valsad in the year 1985, obtained law degree from KM Law College, Valsad in 1988, and Sadar on 18th November 1988. His Lordship was born in the family of lawyers and hails from Valsad in South Gujarat. His Lordship had started his practice at Valsad from January 1989 and shifted to Gujarat High Court in September 1990 and had practiced in all branches of law. His Lordship has worked as member of Gujarat High Court Legal Services Committee and was standing counsel for High Court of Gujarat and its subordinate courts since 2002 and continued as such till elevation to the bench. His Lordship was elevated as Additional Judge High Court of Gujarat on 17 February 2011. Welcome, my Lord. Now, I would also like to introduce Honorable Mr. Dr. Justice A.C. Joshi Sahib, Judge High Court of Gujarat. His Lordship was born on 24th January 1961 at Amreli and done graduation in microbiology from Gujarat University, Ahmedabad in 1980. His Lordship obtained law degree in the year 1985 from MS University, Baroda, and LLM in the year 1989 from Saurashtra University, and received gold medal in Masters of Law by securing first class in December 1990. His Lordship obtained doctorate in subject Constitutional Law in the year 1995 from Saurashtra University. His Lordship started practicing law from 1986 and was appointed as a civil judge and judicial magistrate first class in the year 1991. After his appointment as a civil judge, his Lordship had served at various posts in the trial judiciary of Gujarat. His Lordship has written research papers which are published in GLR and GLH. Professor Dr. N.R. Madhavan Menon, former first director of National Judicial Academy, Bhopal, during his visit to Gujarat in the year 2001, appreciated his Lordship's work, stating as under, I quote, Dr. Justice is an asset to any organization, and we owe a great deal to his kindness and selfless services during our entire visit. I unquote. Professor Dr. N.R. Madhavan Menon also published a book, Turning Point, wherein also his Lordship's work was appreciated. His Lordship was elevated as Judge High Court of Gujarat on 3rd of March 2020.
The speakers who will be enlightening us in this second session are Ms. Sadhana Ramchandran, Senior Mediator Delhi, and Srimati Sushila, Senior Mediator Bangalore. Before starting the session, I would also like to introduce the speakers for the session. Ms. Sadhana Ramchandran, Senior Mediator. She is an advocate on record of the Supreme Court and an alumnus of Lady Sri Ram College and the Faculty of Law, University of Delhi. She has completed over 42 years at the bar. Her practice has been in the almost all branches of the law. She is a lawyer mediator from 2006. She had received her basic training in mediation in India and her advanced training at the S.J. Queenie College of Law, University of Utah, USA, and the Strauss Institute for Dispute Resolution, University of Pepperdine, Malibu, USA. She is an accredited mediator of the Singapore International Mediation Institute. She has conducted mediations in all genres of disputes. In recognition of her work in mediation, on 3rd December 2018, on the occasion of Lawyers' Day of India, she received an award by the Bar Association of India, the first to a mediator, for her contribution to the development of the legal profession in India and for her deep involvement and engagement in the promotion and maintenance of the highest standards of the bar. Welcome, ma'am. The another speaker of this session is Srimati S. Sushila, Senior Mediator, Bangalore. Srimati S. Sushila is a designated senior counsel practicing in the High Court of Karnataka at Bangalore. She has done her master's in sociology, a postgraduate diploma in industrial relations and personal management, and postgraduate diploma in alternate dispute resolution from ICADR. She has been in active practice since 35 years. Srimati S. Sushila is a trained mediator trained from ISDLS, USA and ADR ODR, UK. She is a master trainer from Bangalore Mediation Center. She is a senior trainer recognized from MCPC, Supreme Court of India. She has trained many lawyers, judges and professionals in mediation. Now I request the Honorable Chair and Co-Chair to take over the session. Sir, please.
My esteemed brother, Honorable Dr. Justice A.C. Joshi, respected Ms. Sadhanaji Ramchandra, respected Mrs. Sushilaji, Senior Mediator, Bangalore, respected Shri Niranjan Bhai Bhatt, all viewers, all respected seniors, a very good afternoon to all of you. We are starting with the second technical session of this webinar, Re-energizing Mediation Moment Post-Covid-19. In this second technical session, we have two very well-renowned, respected senior mediators, Mrs. Ramchandra, Mrs. Sushila. And the topic of discussion in this session is conflict in the context of mediation, understanding and transforming it, key dimensions of conflict resolution. This word conflict, in terms of mediation, assumes great importance because it is this conflict which has given birth to this mediation. We should make the most of the expertise of both the renowned speakers. Before I request Ms. Sadhanaji Ramchandra to take over, I would request my brother, Justice Dr. Joshi, to say a few words. Dr. Joshi.
Thank you very much. Thank you very much, my lord. My esteemed elder brother, Justice J.B. Pardiwala sir, and learned speaker, Ms. Sadhna Ramchandraji, and learned speaker, Srimati Sushilaji, Senior Mediator, Bangalore. First, at the outset, I am thankful to Honorable Patroning Chief, Honorable Chief Justice, the Gujarat State Legal Service Authority, and also Honorable Executive Chairman, Honorable Dr. Justice Vinit Kothari ji, for availing me this opportunity to co-chair this function. The topic which is allocated to us is the conflict in the context of mediation. I fully joined with my elder brother, Justice Pardiwala sir, that the word conflict itself is very conflict, and if the conflict is known to any mediator, then I am sure that the mediation process would become very easy, because it is the conflict which drives this mediation process. There are many reasons for the conflict, but we have what my elder brother says, that we have a very good the learned speaker, so we may not discuss more. I'm from our side. I may say a few things that the conflict is hard nuts to crack it, and once it is cracked, then I think it is very easy. So the role of the mediator is very, 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 very difficult to that extent. So far as the young students are there, young judges are there, younger. So to them, I may say in a very simple language that if there is a seasoned, the trained mediator mother who has a problem of is a little problem where there is a single orange, and both the daughters are asking for the orange, and if the father is busy and just say in the ways in which the Lok Adalat we say is that you make half to both, then the problem would be solved. But the mother is mediator, and she would say that she will invite the questions for what purpose you need the orange. Then there's one of the daughters says that she requires for a project in school, and another daughter may say that the orange is required for juice. There is only single orange, and then the solution we all know that by removing the upper layer of the orange, one of the sister can get for the orange for project and juice for rest from the juice. That is what the skillness of the mother. Therefore, I learned this from when I were the PDJ in the subordinate courts. At that time, the Niranjan Bhatt has given this illustration. So what I send message to these young lawyers, the young judges and the law students, that if the mediator has a 40 hours training and the 15 years experience in the process, in the mediation, then I am sure that by knowing the conflict, we can have a very good solution. Ultimately, it restores the relationship coupled with the peace. Thank you very much, the elder brother Justice Pardiwala sir, and also Honorable Patron-in-Chief Dr. Justice Vinit Kothari sir, for availing the opportunity. Now may I switch with the permission of my elder brother, may we switch over to microphone to learned speaker Sadhna ji.
Yes. Ms. Sadhna ji, you may take over, please.
Thank you very much, Justice Pardiwala and Justice Joshi, for your nuanced comments, not just on conflict, but on the nature of mediation itself. And that just shows the kind of leadership that Gujarat has amongst the judges. And we are really grateful to you for this opportunity.
On the contrary.
We're very grateful to Justice Kothari. We are really grateful to you for giving us this opportunity. It is my privilege to share the stage with my esteemed colleague and dear friend who I admire greatly and who has been a leader, pioneer in her own way in our journey mediation. I'm also very happy that I'm sharing today's stage with Niranjan Bhai, our guru, the pioneer of mediation in India, who has turned 87 in his 88th year. As we can all see, he continues to inspire and he continues to motivate. With that, I'll plunge straight into the session. Sushila and I have divided the session in a certain way. So I will be dealing with the concepts of conflict and the key components, and she will be dealing with the very, very important aspect of conflict resolution. So before we actually begin to look at conflict, I'd like all the participants, the judges, the lawyers, the young students who are watching, to imagine 3 scenarios. The first scenario, we are all familiar with all the 3, but the first scenario is, imagine a couple who already have a mutual consent divorce decree in their hands from the trial court. And they are before the High Court for quashing of the allegations of cruelty under Section 498A, which the wife has instituted against the husband. A routine scenario, we would all say, especially the judges, because this is what you see often. Scenario number 2. There is, imagine, a suit for dissolution of partnership and rendition of accounts, along with the division of assets filed by one partner against the other in a partnership that has gone sour. And the partnership is in the important business of real estate. The facts are further complicated, as they always are in matters of real estate, because the partners have taken loans from various banks, and those various banks are in various troubles, which are familiar to all of us. Scenario 3. Imagine there are 100 workmen who have been removed from service. They worked in a charitable hospital owned by a very, very illustrious business house. And inter alia, the reasons given was that they are not permanent employees and therefore not entitled to the rights of permanent employees even after 20 years. And even after 20 years, the workmen wish to stay in this very, in their jobs, which is a very interesting factor. They go to the industrial tribunal. The tribunal, they succeed. Tribunal holds them to be permanent employees, gives them continuity of service, full back wages, and all that they had asked for. The industrial house moves the High Court in a writ petition challenging the award of the industrial tribunal. Very common scenarios. But in this case, the workmen are out of funds. They have fought, they've succeeded, but they are now out of funds. I'd like you all to please stay with these 3 examples, because I would wish to take you through these examples. We all know what would happen to the 3 examples, 3 scenarios in a court of law. What we don't know is what happened to them in mediation. These are not fictitious scenarios. These are real life mediations. Matters referred, disputes referred to mediation that I've had personal experience of. Now, conflict is a huge subject. There are several books on just certain aspects of conflicts written. And we are aware of some of them. We, lawyers and judges, and I would include the students, have chosen a career in conflict, dealing with conflicts, but it was never taught as a subject in law schools. In India, conflict is taught in schools of management, but when the notification of the Bar Council of India came on the 13th of August, 2020, I was thrilled. For the first time I saw item number 1 was conflict in the notification, which has gone to all the vice chancellors to include mediation and conciliation as mandatory subjects. So finally, I've been 42 years at the bar. Finally, I find last year conflict is included in the study of legal education, particularly in mediation. So let's begin with just looking at what is conflict. When we define it, this is one definition, which in simple terms, conflict can be defined as opposing ideas and actions of different entities, resulting in an antagonistic and hostile state of affairs. Nothing exhaustive about this definition, but I want to share that from my experience, conflict is really, it grows out of two social facts. One is difference. You have that difference here in this definition. Difference and interaction. If we didn't have difference and we didn't have interaction, there would be no conflict. If we were all similar in terms of our ideology, our values, our philosophy of life, our economic condition, our standard of living, and then we interacted with each other, there would be a minimum conflict, if at all. Similarly, if we were very different, as we are, each one of us is different. Being different, if we were isolated in our little bubbles and not interact with anybody, there would be no conflict, because we wouldn't even know that differences existed between us. So I would like to share with you, conflict arises out of differences and interactions. And that is a fascinating study for lawyers, for mediators, and of course, for judges. Does conflict come naturally to human beings? Beautifully, in the previous session, we heard Justice Bokani. Justice Bokani beautifully look at this aspect. Does it come naturally to human beings? The clash of thoughts and ideas is a part of the human experience, is what she said. And how right. Is conflict destructive? This is a no-brainer. It can be destructive if left uncontrolled. We all know that. But is conflict only negative? This is where conflict in the context of mediation fits in. Is conflict only negative? For mediators, conflict brings opportunities for learning and understanding our differences. On a broader note, it shapes the human condition. It sharpens our identities. It creates self-awareness about the values, the principles, the beliefs, the ethnicities, the properties that we don't have, as well as the skills that we do have. And in that sense, conflict is a creative social process. We like to say in mediation, as mediators, that fire from conflict sparks change and sparks transformation. And that is the role of the mediator, to get the best out of conflict and to avoid the worst or get rid of the worst. Is there a difference between conflict and dispute? We have a certain language in law, and in that, a conflict doesn't come to court. We don't talk of a conflict coming to court. We talk of a dispute coming to court. So is there a difference? A dispute is often described as a particular incident that is a visible piece of the larger continuing hostilities, which is the conflict. So conflict is large. There are emotions. There is a background. There are influences. But what comes to court are the facts. What comes to court is the evidence. What comes to court are legal arguments, the rights of the parties. That's what comes to court. The conflict does not. And it's not possible for the conflict to come to court. Is it possible for conflict to be addressed in mediation? Yes. Because as JP said in the previous session, any conflict that involves relationships is fit and appropriate for mediation. So therefore, let's go to the categories of conflicts. There are interpersonal conflicts that refer to conflict between two individuals. There are interpersonal conflicts, the most important one, especially for a mediator, that arises within an individual. When the mediator has to really make himself or herself fit socially, emotionally, in every sense, to be a real, what is called a neutral mediator or a neutral person with empathy. There are intergroup conflicts that arise among individuals within a group or a team. There are intergroup conflicts which arise among different groups or teams or within an organization. And we have enough political and international examples in our country and outside. So none of these really need any explanation. They are self-explained. What are the causes of conflict? The American psychologist Daniel Katz listed these three. Again, not an exhaustive list, but broadly, these three areas are where conflicts come from. What is an economic conflict? An economic conflict is one where there is paucity of resources. So the disputants are fighting for the limited resources that they are. And then what do? They become hostile towards each other, and there is a conflict. Value conflict. Values are about ideologies, and we in India are very familiar with those kind of conflicts. When there are different ideologies of different people or groups, then they clash, and each one wants to assert their superiority. So therefore, hostilities happen. And finally, power conflict. Power conflict is when parties intend to maximize the influence that they have socially, professionally, economically. And then what happens? Then situations arise where they need to assert themselves, and so hostilities happen. There are three dimensions of conflict I'd like to look at with you now. The first is the conflict core. What is the core? The sense of threat that drives the conflict. The second component, and these are key components you can call them, is the spiral. How does the conflict grow and how does it escalate if it is not addressed? And finally, the conflict triangle, the three aspects of conflict that mediation addresses. So before I go to these three, I'd like to take you through what we call the continuum of tension. If we look at this, what is the beginning of tension? The beginning of tension is differences. We have differences. When they go unaddressed, then what happens? There are disagreements. If disagreements are unaddressed, then what happens? They lead to problems. These are all nomenclatures, but these are, in essence, they are the growth of tension amongst individuals, amongst groups, amongst disputants. So if a problem remains unresolved, what happens? It leads to what we call a dispute. And that is what we are very familiar with in terms of legal lingo. A dispute has arisen, it has come to court. If a dispute is unresolved, it's called a conflict because it becomes larger in every sense. If a conflict is unresolved,
and violence.
There is violence, perhaps. If violence goes unresolved, there is war.
War.
And if war is unresolved, we don't know. As so many speakers said this morning, we are fighting an unknown enemy. We are fighting a virus. We don't know which way it's going to go. Is there going to be a third wave? Will there be a fourth way? Is it here to stay? That's another kind of expansion of tension. Now let's look at our three examples. The couple that got the mutual consent divorce, where were they in this escalation of tension? Definitely they were at the dispute because they needed to address their problems, whether it was insecurity, whether it was abuse, whether it was, we don't know. Was there violence, mental or physical? Perhaps. Which is why perhaps good sense prevailed on them, maybe some influence, and they thought that mutual consent, divorce in spite of 2 children, was the best way out. So that is what they chose. Yet you will ask, why were they sent to mediation? We'll come to that a little later. Again, look at the 2 people in partnership, the real estate partnership. Where were they in this continuum? They were definitely at dispute. That is why they went to court. But the dispute was much larger. They were 2 families that had actually been dealing with each other in business for several generations. And suddenly there was an impasse. And suddenly there was a problem. Violence, we don't know. War, perhaps because this conflict went public and it was in the newspapers and people were talking about it. So they perhaps were experiencing the entire continuum of the tension. The workmen, where were they in this continuum? The workmen obviously were at dispute, but there was a larger conflict. There had been some instances of violence against some of the workmen, which were revealed in the facts. So they were also pretty high up in the continuum of tension. Now, let us look at the key components of conflict and let us see where our 3 scenarios fit in here. The first is conflict core. Conflicts emerge when something important is threatened and creates initial tensions. What is that most important factor that is affected? At the center of this conflict core is human dignity. When human dignity is threatened, conflict happens. But there are factors which compel people to become helpless, to become dependent, to be confused, to be scared. So looking at this diagram, let us see where our couple were threatened. Where do you think the wife was threatened? Were her psychological needs threatened? Yes. Was her financial security threatened? Yes. Was her social status threatened? Yes. She was a professional. She was a computer professional and had to give up her job because the children were small. To raise the children, the couple had decided that she's not going to work. So her personal reputation was suffered, professional worth suffered. They were living in an army community. Husband was a very, very senior officer in the army. So the community knew about what was happening to them. So all that was threatened. For the man, what was threatened? Maybe his social status, his personal reputation, his professional worth, maybe even his national pride. Oh, how could it happen to me? I'm an army officer. How could this domestic mess happen to me? Did the conflict spiral in the divorce case? Yes. Did the conflict spiral in the partnership case? Yes, it did. Did the conflict spiral in the workman's case? Yes, it did. In the partnership case, what was threatened? Financial security, social status, personal reputation, professional worth, maybe even psychological needs. For the workmen, Their financial security, certainly, because they were suddenly out of jobs. Their social status, definitely, in their own community, they were looked upon as people who were jobless, in spite of their fathers having worked very faithfully for this very well-known industrialist who came from a very humble beginning himself. And when he came from a very, very humble beginning himself, selling vegetables outside on the very road where he had his huge empire today, he never forgot them. And that is why the second generation was very, very attached to him and did not want to leave. So when what is threatened is not addressed and personal responses are not enough, that leads to community responses. Yes, it spirals. Community response doesn't mean just your immediate community. It could be a larger community, depending on the kind of conflict that it is. If community responses are not enough and you're not satisfied with the kind of route you would take, you go for legal advice. And when legal advice is also confusing for parties, it leads to what we call the conflict becoming public. Did the conflict become public for the couple? Yes, it did. Did the conflict become public for the workmen? Yes, it did. Did the conflict become public for the businessmen, the partners? Yes, it did. So when, for a mediator, he or she is faced with this scenario of looking at these aspects of conflict, what does the mediator do? What does the mediator actually deal with? We see that in what we call the conflict triangle. The conflict triangle consists of the people, the process, and the problem. And the people, as you can see on the left side, come with their past, their emotions, their values, their behaviors, their personalities, their circumstances. Now, this is the differences that I was talking about. Difference plus interaction. Process is the interaction they've had. The interaction they've had have not worked. And therefore, the conflict has not been addressed. How have they perceived their problems, their roles? How have they determined their behavior? How have they asserted their positions, made their decisions, communicated? How have they solved the problem? And finally, the problem. The problem is often referred to as the reason for the dispute. So the mediator has to acknowledge the fact that there are people, there are processes that they have used which have failed perhaps, or not succeeded to the extent they should have. And that has resulted in the problem. And the problem also has the reactions of parties, the positions they've taken, their earlier solutions, have they had a problem earlier, their issues. So these three aspects have to be recognized by the mediator for the mediator to help the parties come to a win-win solution for both the parties. What does mediation do? Let's see. Mediation supports people, it controls the process, and it solves the problem. That's the role that the mediator plays. Now, can we go to the next one? In the 5 minutes that I have left, I'd like to just share with you, how does this work? How does the mediator work the conflict? By using mediation techniques like negotiation and communication, which we are going to talk about tomorrow. And what do these techniques do? One, these techniques move parties from a negative to a positive way of thinking. Second, from looking at their past to looking at the future. Third, from the positions they are stuck in to their real interests. And with this, I would like to go back to our three scenarios. And especially for the judges, I think this would be very interesting because these are live cases. The first one, was sent by a very sensitive judge in spite of the fact that the couple had a mutual consent divorce decree in their hands. The judge asked, you've been divorced? And they said yes. This slide can go. They said yes. What? And you have 2 children? Look at the power of mediation and look at the power of the judiciary. You have 2 children? No. I can't deal with this 498A till you go to the mediation center and reconsider your relationship. Cutting a long story short, after mediation was into some 6 or 7 sessions, the man realized the only problem was he was very tight-fisted. That's all. And the woman was resenting it. The lady realized that she was totally influenced by her very, very dominating father. For these 2 reasons, both had signed. And I got a call late night one day telling me, ma'am, we realize what a mistake it was. We are calling from the Arya Samaj Mandir and we have got remarried. Now, this could be an extreme example, but in the Delhi High Court, we have not had just 1 or 2 or 3, but at least 5 examples of ruined marriages getting really healed through mediation. The second scenario, in the second scenario of the partnership between the partners, the real estate issue, the mediator faced an impasse. They were so hostile to each other. Communication was impossible. What does the mediator do? Uses a technique which we will talk about a little later in detail. Unlike a judge who can't call anybody, the mediator asks the parties, your sons are also just entering the business, aren't they? Can I talk to them? He calls the sons. And that changes the game completely. The sons don't want to inherit this litigation. And the fathers don't want to do what they've done to each other to their sons. So that one intervention of the mediator, amongst others, but this was the major intervention, resolves the problem and the suit is withdrawn. In the third scenario of the workmen, I remember we faced such an impasse that when the writ petition was filed in the High Court, the counsel wouldn't appear in mediation. The trustees of the charitable hospital wouldn't appear. We had to keep giving them reminder after reminder after reminder. Then what did we realize? We found what we call the principal agent barrier in mediation. The person whom the workmen worshipped, the person who was in charge, the person who owned the industrial house wasn't in mediation. He was a very, very elderly gentleman, passed away recently. So we sought permission from our honorable judges to conduct the mediation in his office. We went there, explained things to him, made the opening statement that we were bound to do as mediators. And at the end of it, he has tears in his eyes. He had no clue. He hadn't been informed that this litigation was going on and that these children, the second generation of his beloved colleagues who had stood by him when he needed them the most, were in such trouble. What does he do? He opens the door, the workmen come in, they all fall at his feet, keeps the trustees out. There are hugs and tears and of course, after that, they agree to a step-by-step reinstatement. They get much more than they had asked for. They had no funds to carry on the litigation to begin with. And now they get not only their jobs back and everything that they wanted, but they get the love of their chairman, which was beyond what money could buy for them. I think my time is up now. I'd like Sushila to come in with her expertise on conflict resolution.
Thank you, Sadhnaji. Very inspiring, and I shall, at the end of our session, once again refresh your views and your ideas, so that if any of the participants have any questions to put to you, they may put to you, and they would be benefited with your wealth of experience. Sushilaji, Ms. Sushilaji, you may start with your speech, please. Thank you.
Thank you, madam. It's always a great pleasure to listen to Sadhana ji. She has internalized the subjects so very well that one feels as though you are walking through the entire experience that she had gone through. She has laid a very wonderful foundation. The superstructure is also built, and even painting has also been done. All that I am going to do now is to make you walk through the building, that's all. One thing that we need to understand, we are all mediators. Mediation is considered as alternative dispute resolution mechanism. There is difference between conflict resolution and dispute resolution. Notwithstanding that, at times during mediation, a mediator gets a feeling there is an element of conflict here. The dispute is because of the conflict. And until and unless that conflict is addressed, we cannot resolve the dispute. It is only when that intuition comes to the mediator, then he or she steps into the role of doing something to address the conflict. During the course, the conflict may get resolved, or they may try to learn to manage the conflict or deal with it in their own way. These are the three options available. Now you see, any conflict situation we can't avoid. Every day we will have to go through the conflict situation in one way or another. I'll just take you through some slides. 1 second, please. Yes. See, according to Dr. Jenny, who is a very well-known psychiatrist, psychological pain is quite normal. It is important that we have it. We have to go through that. Everyone has to understand that it is quite normal. When we are in a conflict situation, we should know that it is quite normal to get into a conflict situation. We should not be afraid of it at all. That is the first basic principle of resolving any conflict. That's one fundamental thing I would like to touch upon. How does the conflict arise? When needs, interests, values, or goals of an individual gets threatened by the needs, interests, values, or goals of another individual, or there is overlapping of any one or more of these, the conflict situation arises. How do you know whether there is overlapping or not? To understand that, we as mediators should know what exactly we mean by needs, interests, values, and goals. Need is something which can never be negotiated. Need is something which has to be satisfied. If there is an element of need there, then we have to see whether the other person is in a position to accept a situation where he is ready to satisfy the need of the other person. So need is something which has to be satisfied, which can never be negotiated. What is a want? Want is something in addition to need. I have a sari. I'm looking forward to having another sari. That's a need. I have 50 saris. I'm looking forward to buying another 10 saris. That's a want. I have got 50 saris. I'm looking forward to buying 5,000 saris. That's a desire. Neither desire can be negotiated, nor needs can be negotiated. Only wants can be negotiated. Needs have to be satisfied. Now let us understand what exactly is interest. Interest is why you want what you want. I want spectacles. Why do I want spectacles? I am 59 years old. I can't see without anything without these spectacles. So interest tells you why you want what you want. Next is values. When it comes to values, value is something which according to your own judgment is something that is very important to an individual. Different people have a different set of values. It is individualistic. Next is goal. As far as goal is concerned, it's an aim. It's a desired result to which a person focuses. So these are four elements you need to understand. When there is overlapping of needs or interests or values or goals, or any one or more of these of one individual with that of the other, the conflict arises. Now let us go back to the previous slide. If you can see the entire picture, there is a widow there and then two daughters are there. I hope you can all watch that. I'll share a storyline with you people. A rich daughter files a suit for partition against her widowed mother, poor widowed mother, and two younger sisters. She is in Gulf. Her husband is also very rich. She is also very gainfully employed. She comes all the way from Gulf to file a suit for partition against her widowed mother and two daughters of a two-bedroom ordinary house. Then, during the course of mediation, I had to ask her, why did you file this case? Can you please tell me what made you file this case? That's all. She told me the reason. When my father was alive, we were in a very harmonious way, we were living our family. I wanted to get married. I told my father. My father was also happy. I was 25 years old. Look at this, needs. There is no overlapping here. One is, if those of you who are interested in learning more about needs, please read Maslow's hierarchy of needs. He gives 5 different types of needs. The first one is a physiological need, where food, water, sex, warmth, all these things come across. And then is a safety need. And then, as madam said, belongingness and love needs will also be there. And then esteem needs, and then self-actualization needs will come. See, with a marriage, a person may get his physiological needs, safety needs, belonging needs, and then esteem needs satisfied. The father's needs also will get satisfied because it's a prestige issue to get his daughter married in some communities at a proper age. So there is no overlapping of needs here. So as far as needs is concerned, it is clear. But when it comes to interest, why did this daughter want to marry? She wanted to get married because she was in love with, she is Radha. Radha is in love with Qasim, a Mohammedan boy. What is the father's interest here? Father agreed to get his daughter married because father wanted his daughter to marry his sister's son. See here, there is overlapping of interests. Then we will go to value system. What is Radha's value? Any good human being is enough, no matter to which caste or creed or whatever it is. He may belong to any caste, but my value system says that I should get married to a good individual. Mr. Qasim is a very good individual, so I am going to marry him. This is my value system. What's my father's value system? You should not marry out of your community. You should marry from within the same subsect, you can't go to any other subsect also. Same sect, if possible, within the family only. There is overlapping of values here. Goals. Before that, all the people came there and said, look, she wants to marry, let her get married. Even if you oppose also, Radha will marry. Then, father's goals, look at this, aim. He says, let Radha marry Qasim, but after these two young sisters get married. Goal, aim is different. What about Radha's goal? She has to marry Qasim within 3 months. Otherwise, he will fly to Gulf countries. He may get married to somebody else. So goals are overlapping. Because of all these situations, what happened? Radha got married to Qasim, opposing her parents, and went to Gulf. And now, after she went, father died. The widow and 2 children are here. They are continuing the same conflict. They are not allowing her to enter the house. This is the reason she filed a suit. She wanted to file a suit for partition. Look at this. This is where if the needs, interests, values, and goals of one individual gets overlapped with the other, or where there is overlapping, why it had happened, all these things will have to be addressed. If you address it as a simple case of suit for partition, all the 3 children should get, and mother also should get 1 share, 1/4 share, not possible. Section 8 may not be applicable in this case. In adjudication, yes. That's where we have to understand the whole scenario. Needs, interests, and values and goals are to be understood in the proper perspective, depending on the facts and circumstances of each case by the mediator. Now, how do we, before resolving the conflict, we have to understand whether there is a serious disagreement between the parties and it is causing some discomfort. If I am in serious disagreement with Sadhana, who is my sister, I can't sit next to her. There is some discomfort, level of discomfort, that the mediator will observe by observing the body language of the parties. What is within intrapersonal conflict and interpersonal conflict, 2 elements Sadhana Madam Ji told you. With that foundation I am taking here. Something that bothers you within is intrapersonal. So there's a serious discomfort. Number 1, you have to identify that. Issues are non-negotiable according to them. Ho gaya? We lost our father also, Radha's father also died. Issues are non-negotiable. We are not going to compromise. This is the stand the widow and the 2 daughters have taken. Long-term disagreement. Whether it is short-lived or long, conflict is dragging the past into future. On that day it happened. I still remember what happened 35 years back on the day of my marriage. My mother-in-law said this to me. I'm 35-year-old in marriage. Still I don't forget. Long-term disagreement. Heightened tension level. These are the 4 things that give us a clue as to whether there is conflict and it needs to be addressed or resolved or whatever it is. Now, how do you go about it? There has to be opposing interests between the 2 and recognition of such opposing interests. There is something between me and my sister, there is opposing interest, and I should also know, and my sister also should know. Belief that the other will interfere with my interest. I should know that my sister is going to knock off the entire property without giving me anything. That threat, it can be perceived threat, it can be actual threat, whatever it is. That should be there. And the other person also should know. My sister also should know. Oh, Sushila is having a threat. She is feeling that I am going to encroach upon her rights. So both the parties should know that one is being threatened and the other is threatening. This is also there. And there has to be actions that reinforce such inference. For example, go to the case of Radha. I am not being accepted. I want myself to be accepted by my family. What are the actions that reinforce? When I go and knock the door, my mother doesn't open. She instructs my two siblings, my sisters, not to open the door. One sister wants to speak to me through the window. She pulls her back. So actions that reinforce such inference. That is where you need to understand these four quarters very well. How do we deal with conflict resolution? There are different techniques. One of the techniques I use in my mediations and in my personal life, and when parties come to me for some advice also personally at a different level, I have always been following the stop-and approach, which Dr. Jenny recommends to a very great extent. I'll tell you, Dr. Jenny says there are three ways how we handle conflict. One is the avoidance. We all do it. Irrespective of our positions in life, we avoid. We avoid talking to the person with whom there are chances of getting into conflict. We avoid that person itself. Or even when we talk to that person, we avoid talking to that person about that topic. I will talk to my husband about everything under the sun, but not about my mother-in-law. Because when we talk about my mother-in-law, something goes wrong between me and my husband. So we avoid the person, we avoid talking about that person, but we talk about that situation or that person in their absence. Look at this. My mother-in-law is not here today. She is not listening. She can't understand English. That's why I'm boldly talking to you. Why? Because this is one way, avoidance. This is one way which normally every one of us want to feel safe. So we want to avoid that. The second is getting aggressive. We have seen in most of the situations, one is very dominant in our families. We have seen either the elder member of the family, elder brother or younger brother or whoever it may be, or the wife, or in some cases husband, or in some cases wife's sister or wife's mother. They rise and they are all other persons shut down and move away. They don't even sit there to talk. This is the second aggressive part. In both these things, Dr. Jenny says it is not healthy situation. You should not avoid conflicts. You should meet conflict. You should address conflict. You should try to resolve the conflicts. The third one is non-aggressive conflict resolution. This is where we suggest people to adopt this method every situation, be it between boss and the subordinate, be it between father and the child, whatsoever may be. In any relationship, we suggest for resolution of conflict, you must always adopt this non-aggressive resolution. How do we do this? Let us go to the stop-and approach. Stop-and approach says identify the source of the conflict. First, we have to identify the source of the conflict. It can be a person or it can be a situation. You identify the source. Then you identify the time when you should talk about this conflict with the other person. You should identify the time. Supposing I have some conflict with my husband, I can't be talking to him as soon as he wakes up, or when he is drinking coffee, or when he is about to go to office, or as soon as he has come from office, or when we are going to bed. We should not be talking about conflict. When do we talk? We have to choose an appropriate time. It is not just appropriate time. Time includes place also. You should also choose an appropriate time and place. You should choose a place, calm place. This is what we call a setting an atmosphere in mediation. It's a wonderful technique. We set the atmosphere in such a way. In mediation, this time and place problem will not arise. In our day-to-day life, this problem will arise. We have to choose the time and place. As far as mediation is concerned, mediator provides proper time and place, atmosphere. So source is to be identified, time and place has to be identified. Then amicable approach. I don't talk to my husband about the conflict that's between me and my husband all of a sudden. I start with an applicable approach. I appreciate the positive things in my husband and then go to next. So amicable approach is you start telling something you appreciate from the bottom of your heart, something that is good in the other person, whatever be the relationship between two disputing parties, be it commercial mediation or family mediation. There will be some elements where one appreciates the other person. Ask them to speak about that first. Next, behavior. After these 3 quarters are over, I talk to my husband about the behavior of my husband with which I am upset. Behavior. I tell the behavior with which I am upset, and then I tell what I need. Then I leave it to my husband. It is for him to respond in his own way. May I now request Mr. JP Baya? JP brother, are you there? Mr. JP?
Yes, yes.
Yes. We will just demonstrate as to how we are using this Tauben approach. I am Sushila. Mr. JP is my husband. I have a conflict situation. It is 4 o'clock in the evening. I know the source of conflict is my husband, that is JP. And it is 4 o'clock time I have chosen. Me and my husband, we are both in a park. We are sitting in a bench. In that park, usually people start coming from 5 o'clock afterwards. So I have chosen the time 4 o'clock and I have requested my husband to come there at 4 and he is there and I'm also there. Now, source, I have identified Stauben process source, husband. Time and place, I have identified 4 o'clock and bench on the park, bench in the park. Now, amicable approach. JP, we are married for the past 35 years. I'm really happy that you have given me such a wonderful status as a wife. You have been an excellent father. You have been so cooperative when it comes to bringing up the children. But for your support, I don't think our children would have been in such a position as they are in now. I would like to share something with you. In these 35 years of time, you have traveled all over the world, maybe 50 times or even more than that. Every time you go abroad, you bring wonderful gifts to everyone. But never, never, never you have given even a small pin or pen to me. After you give gifts to everyone, very expensive gifts you have given, I have seen. Some persons who are important from your perspective, some persons who are not important from my perspective also I have given. But you have never given me anything. Everyone asks me, what did your husband get you? What did your husband get you? 35 years is too long a time. I'm upset with this behavior of yours. I'm shattered. I'm disappointed. I feel I'm neglected by you. I feel that I'm not respected as a wife. I need respect from you, JP.
I'm so sorry, Sushila. I never thought we were two separate people. I consider both of us as one. I never realized that I need to get something for myself. I got little gifts for others. But I'm sorry. Next time I'll ensure that I get a gift for you too. Will that satisfy you?
Oh, JP. Now I understand that you never thought me as another individual, but you thought both of us are one. Wonderful, JP. I don't want any gift. This is the best gift you have given to me today. I'm so happy. All my tensions have gone. Thank you, thank you, thank you. Thank you, my God. Yes. See here, look at the husband's perspective. 35 years, this lady has been boiling from within. But look at this husband, his perspective. I have not got anything for myself. We don't get gifts for ourselves. And my wife is none other than myself. So I need not have to get her anything. This is how he has looked at it. This is a small example. But in mediation, several conflict situations will be there. We make the parties understand. In private sessions, we tell them about the Steuben process. In the sense, we don't tell all these things. We tell them, start with something that you want to appreciate in the other person, and then tell about the behavior, and then tell what you need. Then the response of the other person. The response can be anything, but they should be prepared to receive it. So this is how we proceed in this conflict resolution. I adopt this Steuben process always. I tell you an example of a bank suit. If it is a simple bank suit for recovery of money, probably it's between the manager and the borrower. Nothing personal. He has to repay the loan. But as far as one case was concerned, the borrower was capable of repaying the loan, but he was not interested in repaying the loan. In private session, he said, look, madam, this loan was taken because my brother wanted to get admitted to medical college. So I had to take a personal loan in my name. And now my brother is a very, very, leading doctor in a particular famous city, and he has got multiple properties in his name. He has never bothered to return that money. So this is where I am. Every time I think of repaying this loan amount, I feel, why should I give this? Why didn't my brother do this to me? So the conflict is not between the disputing parties, bank and the borrower. Plaintiff and defendant के बीच में conflict नहीं है. But there is conflict between one of the disputing parties and another person, because of which this dispute is not getting resolved. We get the other person also, adopt this Steuben process. The brother says, madam, I thought that if I repay that loan, I never knew that that loan is not repaid at all, number one. I thought if I repay that loan, my brother will feel very offended. That's why I did not repay it. I'll repay it. Give me 1 week's time, I'll repay it. The matter got resolved. This is how we move from one stage to another. Now it is 3 minutes left. I would like to thank all the concerned for giving us this wonderful opportunity to share something we had to say on these topics. Thank you all.
Thank you, Madam Sushilaji. The talk was brilliant. I'm short of words. We can now proceed further. If any of the participants would like to put any questions to the two respected speakers, please, you all may go ahead.
Sadhna ji.
Please go ahead.
Sadhna ji.
Is that Justice Joshi?
Audible, yes.
Yes, Judge.
Audible?
Yes, audible.
First of all, for the first time, I had an occasion to know about the developments of conflict, that means in development of the continuums of tension, which you referred to in your excellent speech. And you said that, this is just for clarification of my thinking, not as this, that dispute invites the courts. Means there is a dispute, then one has to approach the courts. And if there is a conflict, then one has to approach mediation, right? But in a pre-litigation, a pre-mediation, I think for the roots of the mediation is differences, disagreements, problems, disputes, and conflict. So in pre-litigation or pre-mediation, even if there is if the stage is not reached up to the disagreement, problem, dispute, or conflict, then one can approach what you said. Even in differences, because differences is the root, where if it is unresolved, then it will invite disagreement. If the disagreement is unresolved, then it will invite problem. If the problem is unresolved, then it invites disputes. If the disputes are unresolved, then it invites conflict. And if the conflict naturally unresolved, then violence, war, and etc. So my anxiety that even in pre-litigation or pre-mediation, we may approach to these differences and disagreements. We can apply this thing without waiting for conflict or this dispute.
You really touched a very important aspect, Judge. You are absolutely right. In pre-litigation, we need not wait. But if in pre-litigation or in a situation which is in court, let's take pre-litigation, it doesn't necessarily have to be the lesser parts of the conflict. Even in pre-litigation, a huge conflict, a large one, which has even gone up to say war. And when we say war, we don't mean actual war, but we mean all kinds of wars, whether it's a media war or a war between, two partners, even in a law firm, that was referred twice to mediation and ultimately went back to court. So, I mean, so the gamut of the tension can be referred to pre-mediation, pre-litigation mediation. Pre-litigation mediation, just as JP was mentioning in the previous session, there is nothing to gain or lose. There is no question of face saving. So you've gone there absolutely fresh with your problems, and it's an open slate. Whereas in court, when we talk of mediation that is referred from court, that can be referred at when it's a dispute, it's in court. It's not as if when it's a conflict, it's not in courts. And as a judge, you would have experienced conflict in a manner in which we mediators have never experienced.
Exactly.
So I would like to just underline what I was saying earlier. In the three examples that I gave, just look at the foresight of the judges. The referral judge. Mediation begins with the referral judge and ends with the referral judge. And look at the kind of understanding they had of the human person, the person and the problem, because it's only in certain cases they've had the confidence to send these kind of matters, where they feel that there will be a loser and a winner in court. These referral judges felt we don't want any losers. Everybody must win in all these three examples. So I really admire the insight of judges of human beings and human behavior. That's the point I wanted to underline.
Nice.
Let me recapitulate the views and the ideas of both the respected speakers for the benefit of the judicial officers and the mediators who are participating in this second technical session. I want the judicial officers to pay attention to this. Madam Sadhna ji started with drawing a fine distinction between conflict and dispute. What is conflict and what is dispute? For many, it may sound synonymous. If a person has no idea about what is mediation and the role of mediator, perhaps he may not be able to draw this fine distinction. So Sadhna ji explained what is conflict and dispute. Conflict is large. Disputes go to the court. Thereafter, Sadhna ji gave a fair idea of various types of conflict, the causes of conflict. How does the mediator work? Sadhna ji also gave a fair idea of mediation techniques. On the other hand, Madam Sushila ji also drew a fine distinction between conflict resolution and dispute resolution. Needs, interests, values, goals, as explained by Sushilaji, that needs can never be negotiated. Now, all this is to be properly understood by the mediator. The example of the mother-in-law, which Sushilaji gave, was very fabulous and quite interesting. Then Sushilaji quoted Dr. Jenny Byrne, her ideas, her techniques. And in the last, don't avoid conflicts, resolve the conflicts. The non-aggressive resolution. Well, I may only say one thing, that at the end of the day, the message is loud and clear. Madam Sadhna ji and Madam Sushila ji and Mr. J.P. Singh has made it very clear that what judiciary cannot achieve may be achieved by the mediator through mediation. That message is loud and clear. The role of the judges. Let me very quickly share a personal experience as a judge. Couple of years back, when I was sitting as a single judge and taking up determination of criminal matters, a matrimonial dispute came to me. As usual, a Muslim family, conservative family, uneducated, boy also uneducated, the girl also uneducated. The boy must be 21, 22 years of age. The wife must be around 20 years of age. And they came to my courtroom with a 6-month-old infant, a newly born infant. The wife was accompanied by her mother, and the husband was accompanied by his uncle. I tried to understand the problem. Why within a short time from the date of marriage, all this matrimonial disputes? I was shocked to learn from the husband that my wife is harassing me like anything. I said, what type of harassment? So he said that she's fond of eating burgers. And every second day she wants a burger. I can't afford a burger. I'm an ordinary man. I can't spend 100 rupees every alternate day. So I just spontaneously said, are you all going to decide the fate of this 6-month-old infant with a burger? And it was difficult for me to make them understand. But then I had to refer the matter to the mediation, and I'm happy to share with you all that the lady forgot the burger. She reconciled. And I don't know whether today they are living as one happy family or not. But this was something shocking, that this could be the conflict between husband and wife. And they were ready to separate. What would have been the fate of that 6-month-old child? Therefore, I may conclude with a very famous quote of Joseph Jimbaum. I really like this quote. An ounce of mediation is worth a pound of arbitration and a ton of litigation. Therefore, judicial officers, mediators, remember the message today conveyed to us by Madam Sadhna ji and Madam Sushila ji, that what cannot be achieved at times by judiciary can be achieved by mediators through mediation. So make the most of this talk, make the most of the ideas of both the respected speakers. Thank you, Sadhna ji. Thank you, Sushila ji. Thank you, Singh ji. It was really a very fruitful session, I would say. And it will go a long way in helping all the mediators in the state of Gujarat. Thank you very much. Thank you, Brother Justice Joshi. Thank you, one and all. Thank you, Justice Dr. Vinit Kothari, for giving this opportunity.
I am also here to thank you all, sirs, and the speakers. It was wonderful to listen to this. And a role play played in even in webinar is a wonderful experience, sir.
Thank you, Dr.
Ji. Thank you, JP Singh, sir. Thank you, Dr. Kushi, sir. Thank you, Padiwala, sir.
Thank you, one and all. Thank you all. Thank you.
We break for the lunch now. Thank you.
Thank you very much, my lords and the speakers, for guiding us, as well as the participants for attending the session.
Thank you.
Now we shall have a lunch break till 2 p.m. and gather back soon on the same link.
Okay. Thank you.
Thank you.
Thank you.
Justice Shastri.
Shastri Sahib, namaste.
Namaskar. It was a good session of yours. Very nice.
Very good sessions. Sadhana ji and
We are really humbled by your kindness presence, sir.
Sorry?
Sadhana ji and
We are really humbled by your kindness presence. Is what I said.
Yes, it's a very nice function. We must all congratulate Dr. Justice Kothari for assembling us.
Exactly.
Actually,
Nice
with such energetic judges, I think Gujarat should have been elsewhere.
Oh, I see.
In the mediation map. It's better late than never.
Oh.
Padiwala sir rightly said that what the judiciary unable to do, that is what the mediation has done.
Sir, still, it is through you. If it comes, it's something else. That's where the court system is time tested.
And ma'am, in the US, 90% of cases goes to the mediation and hardly 10% goes for trial. So that we have to learn from foreign countries, that we should have at least not 90%, but at least 40 to 50% case must go for the mediation.
That's where your lordship's time, money, energy, everything can be devoted on evolution of law, laying down law, all those things. We can think in those horizons. When it comes to only cases that are required to be adjudicated comes to your counsels.
Half the life goes in the court. Sometimes whole life heirs in civil matters, heirs come for decree.
True, true.
So you were also, sir, our mediator once upon a time. Sir took a training at Rajkot.
Yeah. I had taken, sir, madam, 40 hours standing before Niranjan, our respected Niranjan Bhai. And we many times we have called Niranjan when I was PDJ in Ahmedabad and Baroda.
Yeah. And sir, sir, you took a lot of interest even at that time.
Thank you, sir.
Yeah.
Thank you, sir. Because we have seen you at this age. So from Rajkot,
yes, sir.
It started.
Yes.
Madam, you will be surprised that I have taken the the training for twice. First at Calcutta.
Yeah.
The High Court is deputed by Calcutta, the Indo-Australia Conference on Mediation. And second time under Niranjan Bhai Bhatt, respected Niranjan Bhatt.
Fine, sir. We are all together.
Mulyaji is there, sir? Mulyaji? Mr. Mulyaji, Member Secretary? Mulyaji,
Yes,
sir?
Ji, ma'am.
Yes.
You have made us co-host, isn't it, sir?
Sorry, ma'am.
Have you made us all co-hosts?
Yes. All the speakers will be co-hosts. All throughout.
Mudia, sir, your great planning is coming very well, sir.
Yeah.
Wonderfully organized, beautifully organized.
Thank you.
4 o'clock now?
Up to 4. Yes.
We will start on time.
We may start, Lordship.
Yes, Mr. Maulia?
Namaste, Justice Trivedi Sahab. Namaste, Justice.
Namaskar. Namaskar, everybody. Namaskar.
Namaskar.
Namaskar, Niranjan Bhai.
Hello, Ben. We are meeting after a long time.
Long time, and that too virtually, unfortunately.
Yeah.
But fortunately, virtually at least.
Yeah, but this is all well, And
Yes.
We are missing you a lot, Bila Ben.
No, we are so comfortable with this virtual platform.
Yes.
Probably in the High Court, people are not very happy with the now physical opening.
Yeah.
But it's a very good platform.
Yes.
We have to.
Everybody is effectively accustomed with this.
Yes.
We have to gradually find out a way that it can be done in trial court also.
Oh.
It will be done.
Yeah.
It is in the process. The rules are in the process, and I think it's a good idea.
Yeah, very good idea.
And
And everybody should be happy later on.
We can have hybrid system also.
Yeah.
So let's see. At least we are learning a lot from this COVID-19 pandemic.
Yeah.
And this is the best part of it.
Yeah. It is like producing success from a problem,
Yes. We took the opportunity from adversity.
Yeah.
One kind of alternative mode.
Yes.
Belaben, namaste.
Namaste. Joshi sir.
Namaste, Belaben.
Mr. Mulia, you may start.
With the permission of the chair and the co-chair.
Yes.
May I request the master?
Mulia Sahab, thanks a lot.
A very warm welcome once again to all of you. In the third technical session, the subject is overview of the process and stages in mediation, in which topics of discussion are how to take the parties through the stages of mediation, roles of parties, mediators and lawyers in mediation, and importance of ethical dimensions. This session will be chaired and co-chaired by Honorable Ms. Justice Bela M. Trivedi Madam, Judge High Court of Gujarat, and Honorable Mr. Justice Ashutosh J. Shastri Sahib, Judge High Court of Gujarat. Before starting the session, I would like to give introduction of Honorable Ms. Justice Bela M. Trivedi Madam, Judge High Court of Gujarat. Her Lordship was born on 10th June 1960 and was elevated to the bench of High Court of Gujarat as Additional Judge on 17th February 2011. Her Lordship was transferred as Additional Judge Rajasthan High Court at Jodhpur on 27th June 2011. Her Lordship was again transferred as Judge High Court of Gujarat on 9th February 2016. Welcome, my Lord. Now, I would like to introduce Honorable Mr. Justice Ashutosh J. Shastri Sahib, Judge High Court of Gujarat. His Lordship was born on 14 January 1962, done graduation in BCom from HA College of Commerce, Ahmedabad, and completed study of law from Sir L.A. Shah Law College, Ahmedabad. Her Lordship joined as an advocate from November 1985 and have exclusively practiced in High Court of Gujarat, and during the practice handled several cases in civil, criminal, panchayat laws and municipal laws and conducted matters pertaining to constitution. His Lordship has remained as an advocate for several prestigious institutions in state of Gujarat. His Lordship was elevated as an additional judge of High Court of Gujarat on 6th of April 2016. Welcome, my Lord.
The speakers who will be enlightening us in this third session are Srimati Susila, Senior Mediator, Sri J.P. Singh, Senior Mediator, and Sri Paresh Bhai Jani, Senior Mediator, Ahmedabad. Today in earlier sessions, we had introduction of our esteemed speakers, Srimati S. Susila and Sri J.P. Singh, Senior Mediators. Warm welcome to both of the speakers. Now I would like to introduce newly joined speaker for this session, Sri Paresh Bhai Jani. Mr. Paresh Bhai Jani is a leading solicitor of the state of Gujarat. He was also attorney of the High Court of Judicature of Bombay. Real estate matters, conveyancing and insurance are his main field of legal practice since 1976 in Gujarat. He has also secured first rank with first class in LLM Property Group. He has been awarded PhD by Gujarat University in the subject of mediation. He was also a part-time lecturer of Nav Gujarat Law College for about 10 years. He has been associated with many social, educational, and religious institutions. He is president of Ahmedabad Bar Association and also member of Bar Council of Gujarat. Very warm welcome, sir. Now I request the Honorable Chair and Co-Chair to take over the session. Sir, please.
Good afternoon, everybody. My esteemed colleagues who have spared time in this second session, my co-chair, Justice Shastri, our Bhishma Pitama, Shri Niranjan Bhai Bhatt, and other eminent speakers, and our guests from all districts. I think we all have re-energized ourselves by having a lunch. It's difficult to say whether it was sumptuous or not for everybody, because in webinar, it is difficult to say that. In seminars, we do have sumptuous lunch, but presuming that we all had good lunch and we have re-energized ourselves. The reason for which we have assembled today is for re-energizing the mediation movement post-COVID. Probably, I presume that Justice Kothari, Dr. Justice Kothari, when he selected this topic, had this shloka in his mind. Sarve bhavantu sukhinah, sarve santu niramaya, sarve bhadrani pashyantu, ma kashchit bhagavath. May all be happy, may all be free from illness, all see what is auspicious, no one suffer, let there be peace, peace and peace. So with this great idea, we have assembled here today. From the topic itself, the very word, use of the word re-energizing indicates something, that we lack energy somewhere in this movement. As we all know that this movement had started, Niranjan Bhai had said, we all had attended that conference in 2000. 20 years have passed, but we are not still picking up the momentum which we had expected. Initially, there was a lot of enthusiasm, everything. As Justice Kothari said, that now since it had gone in sleep mode, we need to re-energize. Very rightly so. Niranjan Bhai pointed out some of the challenges, like lack of infrastructure, lack of trained mediators. We don't have that mindset, so we need to have proper mindset to have this kind of movement. I would add one more, which according to me is quite important, is that this entire movement of mediation is not backed by proper legal framework. We see the legal route of mediation only in Section 89. While the court refers the matter to one of the modes of settlement, Section 89 is invoked. 89 says that court may refer to arbitration, conciliation, lok adalat, mediation. When it is referred to arbitration and conciliation, there is an act called Arbitration and Conciliation Act. When it is referred to lok adalat or judicial settlement, it is again governed by the Legal Service Authority Act. When it is referred to mediation, then it says that the court shall follow the procedure as may be prescribed. I have my own doubts whether all the high courts have so far framed the rules for mediation, and if framed, whether they are pressed into service anytime. What we are doing at present is judicial settlement, I would say. It is, the parties are sent to mediation. Of course, there the mediation procedure is being followed. But when it comes back to court, again, the court has to pass the order or decree. It has a sanctity, no doubt about it. But Supreme Court, way back in 2010, in that case of Afghan infrastructure, while dealing with the issue of Section 89, how badly it is drafted, I had expressed very, rather was not happy with the drafting of Section 89. I would like to read that for the benefit of all. What is wrong with Section 89 of the code? That was the question posed. And the court has said, Justice Ravindran, as he then was, he said the first anomaly is the mixing up of the definition of mediation and judicial settlement under Clause C and Clause D of subsection 2 of Section 89. Clause C and D of subsection 2 of Section 89, Clause C says for judicial settlement, the court shall refer the same to the suitable institution or person who shall be deemed to be local. Clause D provides that where the reference is to mediation, the court shall effect a compromise between the parties by following such procedure as may be prescribed. It makes no sense to call a compromise effected by a court as mediation, as done in Clause D. Nor does it make any sense to describe a reference made by a court to a suitable institution or person for arriving at a settlement as judicial settlement, as it is done in Clause C. Judicial settlement is a term in vogue in USA, referring to a settlement of a civil case with the help of a judge who is not assigned to adjudicate upon the dispute. Mediation is also a well-known term, and it refers to a method of non-binding dispute resolution with the assistance of neutral third party who tries to help the disputing parties to arrive at a negotiated settlement. The mix-up of definitions of the terms judicial settlement and mediation in Section 89 is apparently due to a clerical or typographical error in drafting, resulting in two words being interchanged in clauses C and D of Section 89C. If the word mediation in Clause D and the words judicial settlement in Clause C are interchanged, we find that the said clauses make perfect sense. So what I'm trying to point out is that there has to be, like for arbitration, conciliation, judicial settlement, Lok Adalat, there is a strong legal framework. Whereas for mediation, we have to take resort to Section 89 only. I have my own doubts whether this can be termed as a compromise made in under Order 23. Recently, in case of Kaushalya, 2019, volume 20 Supreme Court cases 277. None other than our Justice M.R. Shah has taken the view that when in the mediation proceedings, the matter is settled in respect of the properties which were not part of the subject matter of the suit, then also it will be binding. But in that case, the court had taken resort to Section Article 142 of the Constitution. As such, for mediation, we need to have a strong legal framework. Otherwise, when we want to see fruits on the plant, we need to see that seeds have a proper conducive atmosphere. Seeds should have proper earth, proper sunlight, proper water. Then only with the passage of time, one can see the fruits on the plant. Same way, with the best of intentions, best of the mediators, best of the trainers, best of the infrastructure, if the legal frame is not there, probably we'll have to wait for some more time to see that the whole movement picks up and it's successful. So I'm sure we have been doing it, but we should not be complacent what we are doing right now. We need to re-energize ourselves, and I would request all the speakers. I can see the dedication and the commitment of Mr. Bhatt. I also know that he has a good team of others, but we see Mr. Bhatt that he is so dedicated to the cause. I would request all of you to take up this issue, that if you are really serious about the mediation, please see to it that it has a legal sanctity, legal force, legal framework behind it. So this is my view, and I thought that I must express this. This is the right audience, and I'm really thankful to Justice Kothari for giving this opportunity to express my views. With these few words, I would request the eminent speakers who are there on the panel. So first of all, Srimati Shushila ji, she will speak on taking the part overview and of the process and stages in mediation.
There is a small change.
Sushila ji.
Thank you, my lord.
Mr. JP will take the first part, the second part.
Oh, okay.
Lord, between us, we decided that we will do it in a particular manner.
Yes.
And, Lord, thank you for raising the issues, but I think it would require a full-fledged discussion, to go through those issues that your lordships have raised. And in fact, only suffices to add that there is a mediation law under the guidance of the Supreme Court, which has already been framed and sent to the government.
Oh, that's good. So, yes, that is what I was trying to say, that there has to be something to legally grant sanction to this whole movement.
And Lord, so far as the two assumptions, which are required for a sumptuous lunch, one is to energize, and the second is it can put listeners to sleep. Because after lunch, it's very difficult to keep awake.
That's right.
So I'll try that people don't go to sleep.
You'll have to make it that interesting that people don't go to sleep mode.
But when we started the mediation movement, some people equated it with panchayat system. A little difference in panchayat and the mediation is that before the panchas, parties put their case forward. It does not have the legalese of the court, and ultimately the panchas take a decision for the parties. To the contrary, in mediation, parties actually decide for themselves. It's a forum for self-determination of the parties. And second, mediation in Hindi is referred to as madhyastha. And when we started this movement, a lot of seniors told us, JP Singh, what new that you people are going to teach? We do this every day. Parties come to us, we make them sit together and resolve disputes. But after having undergone the training, their refrain was, yes, now we agree mediation is both a science as well as an art. Like the adversarial litigation, which has several stages. For example, in a court, when a suit is filed, a plaint is presented, it is registered as a suit, summons go, defendant appears, written statement is filed, replication is filed, admission denial takes place, issues are framed, evidence is led, parties argue, and then the judge delivers the judgment. Now, these stages are inflexible. You can't have a written statement before a plaint or a replication before a written statement, or admission denial before the pleadings are completed. But when we come to mediation, mediation also has some defined stages. Now, for the purposes of this webinar, we have actually divided those stages into 6 stages. And let me just refer them to you and place them on the screen. first stage is when after parties join the mediation process, the mediator makes his opening statement. First, parties are introduced, and thereafter an opening statement is made by the mediator. Now, this is unlike what happens in court. The purpose of the opening statement in a mediation session, it sets the tone for rest of the process. And some mediators, we have found, short circuit this process. There can be nothing wrong, more wrong than not doing the opening statement properly. Opening statement has various advantages or purposes. First, it introduces the parties to the mediator and to each other as to who's on the table. Second, it gives the overview of the process and the roles of the mediator, parties, and lawyers. See, because mediator explains, because as we know, most parties do not know what mediation process is about. So in the opening statement, the mediator tells the parties as to what his role is going to be, what is their role which is going to be, and what is the lawyer's role that is going to be, how the process will be conducted. He will be in charge of the process, while the outcome, as I said, is party self-determination. It will be in the hands of the parties. They will decide whether to settle or not to settle the dispute, but the process will be controlled by the mediator. Then the third important thing that the opening statement does is establishes trust. See, I am not known to the parties. When the parties come to me, they see a new face. They had gone to the court so that the judge could decide their dispute. And here it is, the judge is sending them to a new person whom they don't even know. So this is when you make your opening statement, you establish trust. And trust is the only thing that a mediator has power on the process. Because if the parties do not trust him, or if he loses trust of the parties, the mediation is bound to fail. Now, trust is established by three very, very important things that the mediator says. One, that the process is confidential. Whatever we say here and do is not going to be quoted in court. You will not be prejudiced in court. Whatever offers that you make here, they are only for purposes of resolving the dispute, but nothing binds you till you sign a settlement. All the offers are during the process of mediation, and they will be kept confidential. So parties feel free to talk. Then the voluntariness of the process. You have a right of self-determination. You have a choice whether to settle or not to settle. You have a right, in case if you feel the process is not serving your interest, you have a right to walk out. So no kind of pressure is going to be put on you. And this actually puts the parties at ease. Because any other process, for example, if I was to go to an elder for purpose of resolution of a conflict I am in with the other side, or if I go to a judge or I go to a tribunal, arbitration tribunal, they're all coercive processes. Because ultimately I'll have to follow what the other person decides for me. While mediation is not coercive. And the third important part is that I tell the parties that I'm neutral. I have no interest in the matter, and I will help the parties to facilitate their communication. Because what happens when parties go to court, you would have seen in court, they don't even look at each other. One is looking on east, the other looks west. That's what happens in court. Parties don't talk to each other. It's only the lawyers who address the court. And in mediation, the mediator establishes communication between the parties, which has broken down, and helps the parties to bring about a resolution of their dispute. Now, this opening statement therefore becomes a must. There are other ingredients, but I need not go into them for the purposes of this discussion here. Now, after the mediator has made his opening statement, the next important stage is gathering information. Now, unlike court, where pleadings are there before the learned judge, So far as mediation is concerned, we never send the court files to the mediation center. Obvious reasons. One, we do not want the record to be tampered with. And second, is what is stated in the petition sometimes is not the real dispute. Because that dispute has got colored by the legal acumen of the lawyers. A small incident can be given a shape of cruelty in a dispute for dissolution of marriage. So therefore, what needs to be gathered in mediation is information from the parties directly. And how do we do that? We do that by asking them questions. Questions like, in court, mostly when a cross-examination takes place, the questions are close-ended. Answer in yes or no. But when it comes to mediation, since we need to gather information, our questions are open-ended. The questions can be, tell me, what has brought you to mediation? What is the problem confronting you? What is happening? These are questions which will make parties talk. Why, what, where, how? These questions get us information. Parties begin by telling their stories. We call them conflict stories. Because these are stories of the parties where they do not see the contribution made by them in the story. These are blame game stories. He did this to me. He did that to me. Everything is about what the other person did. That's why the conflict, the situation, the perception develops. Because I do not see my role in the conflict situation. I always see the other person's role in creating that situation. And therefore, we call them conflict stories. The advantage of these conflict stories coming before the mediator are, because when parties come into as I told you, they don't communicate in the court. Here, parties self-determination too, so they need to talk. And here, the advantage is they talk to the mediator. In the beginning, all the stories, all the communication, all are addressed to the mediator. What does it do? It helps in reducing anger and tension. Because if they talk to each other, they'll fight. So they tell their stories to the mediator. This brings down tempers. Now, sometimes the stories can be like, some people go on and on repeating, but some people don't speak. So then we encourage them to speak. How do we do that? We again ask questions. Okay, what happened next? How did that make you feel? जब उन्होंने कहा था आपको कैसा लगा? Tell me more about this incident. So idea being to gather information. Now, once I have the entire information on the table, what do? I've heard their stories. Now it's time to define their problem. I come to the stage of problem identification. Now, parties are in a conflict. Ordinarily, why are parties in a conflict? Because they assume incompatible positions. One says, I want divorce. The other says, I will not give divorce. One says, I want the partnership business to be dissolved. The other says, no, I do not want the business to be dissolved. I want the business to continue. If he wants to go, he can go out. One wants partition of the residential house. The other opposes it. Now, these are two incompatible positions which the parties come and take before you. So we have these conflict stories, the problems now being identified. When we draw out problems or issues, you see, issues in court are totally different than issues that we'll draw out in mediation. Issues in mediation are the real problems, the conflict issues, the needs, which are actually creating a problem for the parties. So these two issues can be about their content. It can be about facts, it can be about money, it can be about contracts, or the procedures. Issues can relate to procedures, whether to continue with mediation, whether to go in for arbitration, whether to go back to the court. It could be a case of method of payment, whether should the payment be made now, or should it be paid deferred, or should it be paid in future. It could be time constraint. Somebody wants the money now, paid up now, and somebody says, look, I don't have the money right now. So I can only give it to you after a year or 2 years. I have also suffered business losses. Then there could be settlement obstacles. The third parties may be controlling it. And especially when you talk of matrimonial disputes, it's always the in-laws which may be holding the key. Yeah, never before the mediator. Parties who are in court are the husband and wife. But the real dispute, the persons who control the settlement outcome, or the real dispute emanates from somebody else. It could be mother-in-law. It could be sister-in-law. It could be anybody. So these obstacles may be there. So these may be the issues which the mediator ultimately identifies. Now, after the issues are identified, what are the issues between the parties? What is to be done? You have to set an agenda. What is an agenda setting? I have listed 5-6 issues that are there between the parties. Let's say a matrimonial dispute. Issues could be maintenance. Issues could be custody of the children. Issues can be, visitation rights. So many issues can be there before the mediator in a divorce petition, which ultimately, or a matrimonial dispute which comes before the mediation. So then agenda setting helps the mediator to set up which issue to take up first. Prioritize the issues. And when we prioritize the issues, ordinarily, we take the simplest issue first. Let's say the simplest issue is the visitation part. I feel this visitation issue can be taken up, and can be resolved easily. So we take up first, we park the other issues, we put them in the back burner, and we say, okay, let's first take up the visitation issue. And once the parties resolve the visitation issue, their trust in the process grows. They feel they are moved. Where it looked to them opposing situation, divorce dena, divorce nahi dena. And ultimately, they have now resolved an issue of visitation. That develops trust in the process. So therefore, we have now taken the parties from the opening statement to the gathering information stage, and we have identified the problem, and we have now set the agenda. Shishila ma'am now will tell us where do we go forward from here.
Thank you, JP. It was a wonderful session. In fact, I should say that it was a refresher course for me.
You are kind, Sushila.
No. Just 1 second. Now let us go to a situation where we are into generation of options and evaluation of options. Have I shared the screen? No.
That's not showing.
It's not showing. 1 second. Something wrong here. Mr. Mulyaji, can you just use the yes.
Ma'am, may I know which PPT of yours will run for you?
So you'll not be able to share.
Mulyaji, please.
Made a co-host.
Generation and evaluation of options. Doesn't matter. Even if it is not there, doesn't matter.
You need to be made a co-host. Then only you can share.
Yes, sir, I am sharing. Yes, sir.
Can you share the screen, Mr. Mulyaji?
Yes, sir.
Please bring that PPT. Yes. Can you see? Can you all see, please?
Sheila, yes, go ahead.
So you see, we are looking at generation of options and evaluation of options. What happens in mediation is the cases that are fit for mediations are referred to mediation. I'm speaking about court annexed mediations. If there is an element of settlement, it will be referred to mediation. Going by advance judgment or even otherwise also, we all know which are the cases fit for referring to mediation. That's one part of it. But all cases that are fit for mediation may not be fit for negotiation. All cases that are fit for negotiation may not be ripe for negotiation. This is what we need to understand. Taking a leaf from where Mr. JP has left, the generation of options and evaluation of options should be taken up by a mediator after setting an atmosphere congenial for it. Unless emotions are addressed, reasoning will never work. What all JP has referred to in the other 3 stages of mediation, by that time the emotions should have been addressed, completely addressed. Only when the emotions are completely addressed, we can take a party to the reasoning part of his working. Only then we can assist them properly in negotiation. Mediation is known as assisted negotiation. Now, if we go to the next slide, Mr. Mulyaji, we should know the difference between options and choices. As human beings also, many a times we do lots of mistakes in not knowing the difference between options and choices. As mediators, many of us commit this mistake. Options always have some restrictions. Options are fixed, whereas choices are not fixed. For example, you might have come across this question papers where they will give multiple choice questions. Choose A, B, C, D. These are the 4 options given to us, A, B, C, D. But the choice is left to me. I can put a tick mark to A, B, C, D, or not answer anything, and so that I can get 0 also. That's different. But when it comes to choice, I have to work within the options. Options are those that are generated on the mediation table as far as mediation is concerned. This is one aspect we have to understand. See, the choice is something to choose amongst the options. If that option is not there, supposing sun rises in east, west, north, south, A, B, C, D they have given. I cannot write northeast or northwest because that option itself is not there. My choice is to say from east, west, north, south, I can choose one of the options. That is where we need to understand. When it comes to choice, the right of self-determination of an individual. It is the party's voluntariness that is given more importance. Party's right of self-determination is involved as far as making a choice is concerned. But when it comes to options, party's right of self-determination is not there. Options are generated on the mediation table. Why should we know this difference? Means the moment an option is projected or an offer is given as an option, the other party starts thinking and telling so many things negative about it and tries to walk away. The mediator has to understand the difference between option and choice and also make the parties understand you can park the process of exercising your choice somewhere else, look at the options and then come to that point. This is where I request everyone to say, understand the difference between options and choices. Now, as far as generation of options are concerned, I always fall upon Dr. Edward de Bono's lateral thinking process. Mulyaji, next slide, please. He is the one who has propounded the principle of six-hat thinking. When we come to the situation of this generation of options, be it in our real lifetime situation or any other situation, or we are involved in a dispute, whatever it may be, we need to think about four aspects. The first one is, how do I perceive this problem? We should ask the parties, how do you think? What do you think about this problem? How do you perceive about this problem? How do different people think about this problem or perceive about this problem? That means to say, you think this is the problem. What does your husband think? What does your partner think? What does the bank manager think? What does the opposing party think? What does your mother think about this problem? What does his mother think about this problem? How do different people think about this problem? What I am thinking as a problem, sometimes morning session is very important, where Sadhana ji took you through person, problem, and the solution. All human beings generally are tempted to feel that the problem is bigger than the person. No way. We are the masters of our life. Problem is always smaller than the human being. Human being can handle it. That's where we need to understand, we need to make them how different people understand this problem. When we take them through this stage, they will understand, oh yeah, this problem is not as big as I thought it to be. That is the second stage. Next one, please. Mulyaji. Yes. The third concept is, how do I perceive it differently? You have a problem. You understand this problem this way. Can you think about this problem in a different way? This is where we take them. The next one is, we ask them, what are your options? They will tell. What other solutions can you expect? Tell me, what other solutions can you expect? This is where we make them land in a platform where they start thinking about the options. What different solutions can you expect? What different solutions your husband can expect? What different solutions the defendant in an injunction suit can expect? What different solutions can you offer to the defendant in a specific performance suit? Come on, let us think about it. This is where we set the ground. That is what is known as setting an atmosphere. Once again, it's very important. These are all communication skills, and some of the techniques are also very important because these are all interwoven. When we take them from one stage to another stage, we make them walk through these different stages. Next, please. I was referring to the 6 hats. Edward de Bono speaks of 6-hat thinking: blue, white, green, red, yellow, and black. Generally, in Western context, they say, why are you wearing the red hat? Why don't you keep your black hat aside? Why should not you wear a white hat? We say like that. Let me explain to you in a single sentence. White hat always refers to statistics, documents, etc. Supposing an auto driver's wife comes and says, what is it that you are expecting from your husband in a petition under section 125 of CRPC? Madam, I am expecting maintenance. How much do you expect? Monthly 50,000 to chalega, madam. 50,000 rupees mahine ke liye. Then we use this white hat thinking. What are the assets standing in the name of the husband, etc. Now that Rajneesh Neha case is there, we know the guidelines given by the Supreme Court. What are all the things that are there in the affidavit? We ask them indirectly. That is white hat thinking. In specific performance case, we ask them what are the other properties he has got. We will ask all these questions. Red hat is about emotions. While generating an option itself, they will start making the choice. Your husband is persistent. He is interested in only divorce. What do you think about it? Divorce? No, madam, it's impossible. Why? Till they will agree for all the terms. On the day of signing the agreement, they walk out. They tell, no, madam, something is troubling me. What is it that's troubling you? Till today, I was wife of so and so. From tomorrow, that status is not there. This Sutra is important for me. I'm attached to this. This is called as emotional impasse. So that is red hat thinking. Red hat thinking will always stop a human being from taking any decision. Please understand there are two things in negotiation. One is decision making and another is decision taking. We as mediators assist parties in the process of decision making. Decision taking is absolutely left to the domain of the parties where they exercise the right of self-determination. That's where red hat thinking comes. So before the generation of options, in the 3 stages that JP has referred to, you have to see to it that the red hat thinking should not come in the way. And black hat thinking is something or the other, always negative. You start telling something, oh, that's not possible, that's not agreeable. Don't talk about it at all. Black hat thinking also must be avoided. Next, we shall go to the 2 important things, which is the topic of today's discussion, generation and evolution. Generation is green hat thinking. In generation of options, what we do is, we tell parties, you need not have to accept on anything. Let us only collect all the fruits in a ball. We will collect all different fruits. You can take lemon, or you can take a jackfruit, or you can walk away without taking anything also. The choice is given to you. That is where we bring the choice. But parties think choice is an option. Choice is not an option. Options first, choice next. That's where we say in green hat generation, in green hat thinking, we allow parties to generate several options. What do you think about it? What do you think about it? Sometimes brainstorming is a technique where we use all the parties, we request all the parties to assemble in a hall, and then both sides, and we tell them this is the problem. All of you come on, please tell me what solutions they can have. Let us generate options. So for that brainstorming session, we invite people other than the disputing parties also. Their mamaji can come, her uncle can come, and even a person in our mediation center who supplies tea, chai to somebody, he can also come. JP Singh, who has come from Delhi to see Bangalore Mediation Center, he can also come. Anybody can come. Some co-mediators, some mediators who are there, they can also come. All will start giving one option. We will put all the options in a ball. And then comes yellow hat thinking. Yellow hat thinking is a situation where you start evaluating. You start seeing the value associated with an option. Please see here. We do not evaluate. We assist the parties to evaluate themselves. Whether this option is good or not from your perspective, you have to evaluate is what we tell them. Next slide, please. See, when we go to evaluation of options, parties start, each option we will take. Mulya ji, next slide ko jana hai. Next slide, please. When we start thinking about this evaluation of options, the options which I had thought totally not conducive to me, not acceptable to me, when we start evaluating the options neutrally, then I feel, oh, this was a good option. I had so many negative notions about this option, but actually these options are very wonderful. So the initial, next slide please, the initial negative points, I start to recollect those negative points and I find, Mulya ji, next slide please. I feel that the earlier negative option is only based on my ideas and imagination. That means to say that people suffer more in imagination. And in the process of evaluation of the generated options, we assess them in such a way, we take each option and then start writing about it. We tell them, write the positive aspects about it, negative aspects about it. You only write. Let us discuss on each and then see whether this option is good or not. What happens here is the element of reactive devaluation comes. If JP is my brother and I hate him, any suggestion that comes from him, I don't accept it. But whereas if Niranjan is my another boy and I love him, if any suggestion comes from him, any option comes from him, I at least look at that. If it comes from JP, I just shut my eyes to it. I don't even look at it. Reactive devaluation is a psychological factor which withholds an individual from accepting even the best of the offers given by the opponent. That's where we tell parties, don't look at the person who has given the option. Look at the option. If it is good, you can agree to it. If it is not good, you need not have to agree to it. Supposing, now let us go to a practical scenario. I had a case where a specific performance case was referred to mediation. The landlord, the agreement holder had a son who had come there, and a daughter who had come there as a power of attorney holder, and the landlord had a daughter who had come there as a power of attorney holder. Multiple options were generated. I had to return back the file to court. And the last day, when nothing worked, I started using this and the generation of options through brainstorming. Everyone started giving so many options. There were about 16 options, but none of the options were agreeable. The boy's mama was there who said, "Madam, you are taking so much of strain. This case can get resolved if that boy marries this girl." I was just looking at the boy and the girl, they were looking at each other. Then when I said I am going to return back the file to the court, they said, "Don't want, please hold it on. After 15 days we will come." After 15 days they came, they withdrew the suit, the matter got settled, the site was given as a gift to the other party. Where has this option come? This option is something generated on the mediation table. How did it happen? We do not know. Multiple brains working from different angles will bring in different solutions. Ultimately, the choice is left to the party. This is one aspect we need to understand. And as far as selection of options is concerned, parties always fall back upon somebody else for selection of options. We are all adults. Even to this day, if you want to buy something, it may be a 500 rupees worth shirt or a 2000 rupees worth saree or something small also, we would like to take somebody along with us. Come on, let us go. We don't take decision ourselves. We want somebody else to take decision. And we're all tuned in a system where we always want to give decision by somebody else. It could be by a judge, because we always look upon somebody else, look at somebody else to give decision for us. So the mindset has to change. The authority or the power to give decision is now lodged somewhere else. Authority to take decision, power to take decision is given to the hand of the persons. This is where the paradigm shift is coming. And I'm afraid, what if I go wrong? That is where the assisted negotiation is very important. That is the stage where we enter into an area where we assist the parties in negotiation, that we give them complete freedom. They can go back on their options. Yesterday, I agreed to give 50,000 rupees. Today, I say, no, he has to give me 5 lakh rupees. They can go back and forth until they sign. They have got complete freedom to go back on their promises also. This is one way of looking at it. Now, when it comes to agreement or no agreement, what I request you to see here is what are the consequences of agreement or no agreement is different. But all that I request the mediators and the lawyers to see here is communication in mediation is not just talking to each other. It is connecting to people. Whether there is agreement or no agreement, after 5 or 6 sessions of mediations, parties are made to connect to each other. So we have moved the parties from the situation of stonewalling to greeting at least. This is a wonderful thing that we need to look at. We need not have to look at the end result. We have to look at this. If this happens, probably something else will happen on some other day. A matter which is referred for mediation from the first court may also get referred to mediation in between in a span of 15 years of litigation n number of times. But if the foundation is laid down properly, that communication, if we have moved the parties from communicating to connecting, from stonewalling to greeting, whether there is agreement or no agreement, we can see wonderful results. This is what we need to understand. So to recapitulate the whole thing, whether the 6-head thinking should be done at the last stage, need not be. Individually also we can do. In the private caucus, with one group of people, give your options. We will take a list of options. With the other person, we will take a list of options. And then we will see both those things. And then we will come to a conclusion. There was a strange case which I wanted to discuss with you. The husband and wife were separated for more than 15 years. Suddenly, all of a sudden, the husband filed a petition for restitution of conjugal rights. And he agreed for all the demands by the wife. She said, this I want, this I want, this I want, etc., 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 everything agreed. Then somebody told her, look, your husband is contesting for the elections. So in order to save his face, he wants you to get back to him. This is the objective behind. What do you want to do? They told her right in front of her. Then she asked our suggestions. As mediators, we are not supposed to give suggestions or we are not supposed to advise. I said, you have to, this option is given by your husband to get back to him and leave. See the positive aspects, make a list of it. See the negative aspects, make a list of it. Green hat evaluation, green hat mein ye option aa gaya hai. But evaluation of options mein, whether this option is good for you or not, it is for you to think and then get back to us. After 15 days, she came back and said she is ready to go back with her husband because even otherwise she is living separately here, depending on somebody else. She would rather live there. It is her life, it is her decision she has taken. Why I am telling this is evaluation of options may not be done completely by the parties themselves. They may not be strong enough to evaluate the options. Many a times even we fail. We look back and we regretted the options that we have taken, we have made in our lives. We have the options, the choices of the options that we have made. But nevertheless, what we need to understand here is, if it is an assisted negotiation, in proper evaluation of the options, whether proper time is given and whether they are working from an emotional angle or from the angle of reasoning is to be looked into. Thank you all. JP, your aspect is there. You have to.
Thank you, Sushila. Now we've completed the process. So now the people here have at least a bird's eye view of what a mediation process looks like. Opening statement, gathering information, problem identification, agenda setting, generation and evaluation of options, selection of options, and finally either it results into an agreement or it doesn't result into an agreement. Now, what is the role of the mediator in all this? He is the person who controls the process, and that's why you need training. If you are not trained, how do you control the process? As I said, it's not a panchayat. It's not just bringing two parties together and trying to find a solution to their problems. It is, as I said, a science and an art. So to acquire this art, you need those skills. We talked about conflict. And why are we avoiders? Why do we avoid conflict? Why do we view conflict as something very negative? Is because we do not have the required skills to deal with the conflict. Conflict is bound to arise in life. But unfortunately, we do not have the skills to deal with conflict. Look at the US. In the United States, children leave their home in teens. They practice peer mediation. Children start taking decisions on their own, even in their teens. But what happens in India? When Sushila ma'am talked about dependency, we always expect somebody else to take a decision for us. You know, when a child is growing up, my mother and my father take decisions for me. I start going to the school, my school teachers take decisions for me. I go to the college, my professor takes decisions for me. I join a service, my boss takes the decision for me. And it is not unusual in India, you will find a 50-year-old man, when he loses his father who's 70 or 80, is crying. Babuji, aap chale gaye to hamara kya hoga? Because at the stage of 50, he has not been able to start to take decisions on his own. Somebody else has been taking decisions for him. And that is why we have, even in mediation, when parties get stuck on, see, after options are generated, now comes this question of selection of options. As Sushila said, somebody else will help them to select those options. And it is not unusual when the party will say, sir, aap hi bata do na. He'll tell the mediator, look, please, you only tell us now these options are, which is good for me. And that is the stage where you have to be careful. Because the moment you help them to exercise an option, you will use perceived neutrality. Because if it suits one party and does not suit the other party, he will think I'm taking sides. So therefore, I am nobody to tell as to what suits you or doesn't suit you. That's not the mediator's role. So what is the mediator's role? He is a facilitator. As a facilitator, mediator only takes the conversation or the discussion forward and takes them around the roadblocks. See, at some stage, the discussion can stop. Parties can stop talking. Parties can stop generating options. Now, it is the role of the mediator to keep the discussion moving, not to get them into an impasse situation, not to get them into a roadblock. So as a facilitator, he keeps the discussion moving. The next important role that the mediator actually carries out, that is establishing communication channels. He opens the communication channels between the parties. As we told you, when they come, they start talking through the mediator. It helps in the beginning stage, yes, it stops, tension and anger. But at the end of the day, the role of the mediator is to establish direct communication between the parties, that they must start talking to each other. Is it not an art how to establish this link? In the first instance, what did we do? When the matter comes to the court, it is a large dispute. Divorce hona chahiye, divorce nahi hona chahiye. Are there sufficient grounds for divorce? Sufficient grounds are not there for divorce. But when it came to mediation, what did the mediator do? He broke down that larger dispute into smaller disputes, into smaller issues. And those smaller issues were, okay, let's talk about visitation. Okay, let's talk about maintenance. Okay, let's talk about, custody. And as they go along resolving these small disputes, they ultimately decide, well, it works. And then they take a larger dispute into the right perspective and decide whether should we divorce or whether should we stay together. So this is the role of the mediator. So he opens the communication channels. Then he is the person who translates the information. You see, when the conversation happens, is as Sushila said, it's full of emotion. Charged conversations happen. Wrong expressions are used. He's a liar. He's a cheat. He did this to me. He ruined my life. What does the mediator do? He softens the language by saying, look, he said something. Honesty is very, very important for you. Instead of saying that he's a liar, so for you, honesty is very important. This really upset you. Instead of saying that, so what does the mediator do? These are the communication techniques that he establishes. He softens the blow. He ensures that the tension, the anger, the harsh words are removed from the conversation. That again is an art. Then he distinguishes wants from needs. When he's breaking down that, the larger dispute into smaller dispute, he helps them to identify what their real needs are. Because as Sushila said, needs are not negotiable. Needs need to be met. So he then, creates, okay, these are things, these can be traded, these can't be traded. We'll talk about all this, how this happens in negotiation. So here is again the mediator helping parties how to do it. Then he helps them in generation of options. Why am I telling you all this? Because this is, now you realize this is something totally different than the court system. In the court system, what does the judge see? What is there in the file? The pleadings, the documents which were proved. What is the evidence led? How much of, the real dispute could be something different, but parties were not able to express it. The evidence did not come on record. Ultimately, the judgment will be on the basis of the evidence on record. So the real dispute sometimes never emerges in court. When the mediator takes the parties through these stages, when he actually highlights what their needs are by asking appropriate questions that we talked about, he helps parties realize to do reality test. What is it in their interest? Should they go back to court and fight? Should they decide the dispute here? Is court a better alternative for them? What if we do not settle? What will I do next? These are things which ultimately the mediator helps parties to visualize for themselves. And this is what helps them to ultimately resolve their real conflict or the dispute. Now, these are various, things. Of course, we can go into details when we talk about in the training as to what the real role of the mediator. But this in general is the role what the mediator plays. He controls the process from the beginning till the end. Now, so far as parties are concerned, what the parties' role in court is, in court, as I said, parties treat it as a contest. I must win at all costs. But when it comes to mediation, parties must look at the other person's interests and needs too. Because negotiation is not a one-way street. It's not my way or the highway. I have to also look at the interest of the other side. Unless those needs are met, settlement will never happen. It's not only my needs, the other side's needs also must be met. They can be incompatible. But the question is, we need to deal with those needs. So therefore, parties must change their whole mindset when they go to court and when they come in mediation. So their role in mediation is totally different. And second most important thing when they come in mediation, it must be a bona fide attempt. See, I may make a bridge. This is the example somebody says there are two villages. In between, there was a river flowing. Now the person or the mediator creates a bridge. Now it is up to the parties whether they want to go across the bridge, whether they want to have commerce through the bridge, whether they want to use it as a transport system, whether they should actually use the bridge or not use the bridge. It is left to the parties to take a call. So therefore, parties must honestly, with bona fide intention, come before the mediator for resolution of the dispute. Because there are times when we have found parties sometimes go before the mediator only to pass time. They want to avoid an inconvenient judge. The judge, this judge is bound to decide against me. He doesn't grant stays. So, my lord, we'll go for mediation. But he's really not interested in mediation. He spends time there. He asks for the moon, which he will never get. And then the matter goes back to the court. And by the time the roster has changed. So these are things which you need to be very careful about. And also the party's main important thing is, on the table, there should be the party who can take a decision. It's the important thing that in mediation is the party who can take a decision must be on the table. Because if he's not there, the mediation will never result into a successful mediation. Anyway, we always say mediation never fails. It's parties who fail. So it may not result into a settlement, but mediation always succeeds, because there are times when we have found parties go before the court. Kehte hain na, haathi nikal gaya, pooch atak gayi. Sometimes egos stop them. They get stuck on their value systems, and they're not able to resolve dispute in mediation. But when they go before the court, a little nudge from the judge sometimes brings about a settlement. But what the mediator did was, he brought them to that level of self-awareness. And once they are at the level of self-awareness, they will go and settle even tomorrow. Maybe not before the court. They can meet tomorrow between themselves and decide it. Once we have brought them to that level of awareness. So these are the basic roles, what I can talk about the mediator and the parties at this stage. Sushila.
Let me take you through some aspects of this role of lawyers in mediation. I'll just take 5 minutes time, and then it is our Paresh Jani sir who will take your concerns through the ethical dimensions and importance of the ethical dimensions. As far as lawyer's role is concerned, I sincerely feel that there's a tremendous contribution that mediation can make to a lawyer as an individual and also as a professional. In fact, if we do not work on this now, and if we do not step into getting trained ourselves as mediators, or at least getting training in mediation advocacy, what happens is tomorrow the doors will open and the persons who are not lawyers may also get into. I'm not against that. But what I'm requesting here, my brother advocates, to see here is that those of the advocates who are very young can get trained in mediation advocacy. If you are trained in mediation advocacy, the way in which you are assist in negotiation, assist the parties in negotiation is entirely different. That's where I request the chairperson and members of Bar Council, chairperson and members of the bar associations to see to it that everyone in Gujarat state, every lawyer in Gujarat state gets trained in mediation advocacy. At least 2 days training can be given to them in mediation advocacy. And those who are interested in getting trained in mediation, they can get trained in mediation. Getting trained in mediation is different. Getting trained in mediation advocacy is different. Why am I telling this? See here, as far as the role of the lawyers is concerned, the question here is, what are the different roles a lawyer can play? The lawyer can play participatory role. The lawyer can also play a cooperative role, and it starts with participatory role. Then he moves on to the cooperative role, and then he moves on to the collaborative role. These are the 3 different roles a lawyer plays as far as a mediation is concerned. Sometimes they just participate, and it may even be a mechanical participation. What we generally request the advocates is to see that they participate wholeheartedly. Next is a cooperative role. Next is a collaborative role. Why do I say this? I have seen in many mediations, parties do not even enter the room. I repeatedly request them, please come have your seat, please. They wait there, looking at the watch and looking out, waiting for somebody else. Only when the lawyer steps in, the lady or the man also steps inside. They're so much dependent on the lawyer. They have so much of trust in the lawyer. There's a psychological statement here. I trust that, not because I trust that. I trust that because I trust you and you trust that. Let us take this example. Supposing this is now we are in virtual meeting here, webinar here. Assuming for a while I had come to Gujarat. Supposing suddenly I collapsed. Then you will call my husband. One of you will call my husband. Where should we admit Sushila? Husband will say, shall I admit her to Leela Hospital? Yes. Niranjan Bhai will ask and my husband will say Leela Hospital, yes. Whether that Leela Hospital is good or not, whether my husband has got trust on those doctors or not, my husband doesn't know. All that my husband has trust is, my husband has got tremendous trust in Mr. Niranjan Bhai. I trust that not because I trust that. I trust that because I trust you and you trust that. Even for the referral judges, it is same. When the judges tell that we have trust in mediation, we have faith in mediation, please see whether it works out or not. Otherwise, we will go ahead with it. Then what happens is, it is not a mechanical reference of the case. The files do not move from one building to another. The people with I always keep telling, people with claims are people with pains. They move from one building to another building. That's where the importance of the role of the lawyers comes here. If it is a cooperative role, what happens is, because the people have trust in the lawyer, our judicial system is time tested. Since more than 100 years, we have trusted the judges. We have trusted the lawyers. Today, they don't trust the mediator all of a sudden. So it is through the lawyers the mediators have to work. No mediator can expect any success in any mediation of any kind. I'm not going to the end result, even in the procedural part of it, unless we ensure that there is cooperative role of the lawyers. Lawyers can also get financially benefited. For participating in mediation, they can fix their fees. In fact, as a lawyer, before practicing, I mean, on the as a mediation advocate, and after getting into this, I have seen there's a lot of changes in my earnings also. So I request the young advocates to kindly take upon themselves, request the Bar Association presidents and Bar Council chairman to kindly give them training in mediation advocacy so that they become the persons who can take this mediation movement forward. Now you see, what is mediation advocacy? I'll just explain in a minute's time. It is partnering with the mediator. The lawyer, the advocate, partners with the mediator. How does he partner? He partners with the knowledge of the client. He tells the client, look, I'm going to partner with the mediator in order to see to it that you get the good deal or the best deal. Not only to his client's knowledge, he also makes it known to the other side party and his lawyer also, so that the other side lawyer also does this. It is partnering with the mediator to play the cooperative role and the collaborative role to the knowledge of the opponent and his lawyer also. So participatory role, cooperative role is my client's interest, me as a lawyer, my interest, my professional interest, and the mediator, cooperative role. Collaborative role, my interest, my party's interest, my professional ethics, my opponent lawyer's professional ethics, his professional income, and his client's interest also. This is a collaborative role. So that's where we move from one stage to another stage. This is the role of lawyers that we expect in mediation. Thank you all. Now Mr. Paresh Jani sir will take us through importance of the ethical dimensions.
Thank you, madam. Before I go to the subject, my subject is importance of ethical dimensions in mediation. But before I go to that subject, I will discuss an incident which happened in a tribal area of Dharampur. Dharampur is situated in Valsad district. I was assigned the work of explaining mediation. It was a 2-hour job. And Justice Ilesh Bhai Vora, the present judge of the Gujarat High Court, was district judge of Valsad at that time. I was accompanying His Lordship Justice A.P. Thakur also. He was also member secretary in those days. After the talk was over, 10 to 15 tribal ladies, hard-working ladies, they approached me. And they had a small problem. For them, it was a small problem. For me also, it was a small problem. And the problem was this, that they complained that the ladies as well as their husbands, they consume country liquor every evening. That is their day-to-day habit, daily habit. But thereafter, the husbands, they abuse their wives and they also were beating their wives. Therefore, this was their problem. They wanted this solution. And if the solution is not arrived at, they wanted to file criminal complaint against the husbands. The husbands also said that, yes, sir, we consume country liquor, we abuse our wives, we also beat our wives, and we don't find any solution. You advise us. We will work according to, we will practice whatever, we will work as per your advice. We will follow your advice. What to advise? It was impossible to advise anything to them. I just told them that you should not consume country liquor every day. Drinking alcohol is not good. But then they said that, sir, it is their habit right from their childhood. And they cannot live without consuming the country liquor. They said that even their children also consume the country. But then one old lady who was also accompanying them, she was like a leader of their wives. She said that let us work out one thing. You pledge that you will consume the country liquor only for 2 days of the week. Rest of the 5 days, you will not at all touch the country liquor or the alcohol. The wives were prepared to accept that suggestion. Yes, 2 days you can beat us, 2 days you can abuse us, 2 days country liquor also can be consumed. The husbands also agreed to that suggestion. It was not my suggestion, it was their internal suggestion. They were talking and I was just listening to them. But then what to do? They said that, sir, is it okay? I said that it is not okay. But then they had an agreement, internal oral agreement with them. And then at last they asked me that, sir, please reduce that agreement into writing. Uska likhan kar do और हमारे पास से उसके ऊपर अंगूठा ले. So for me, I just smiled and told them that written agreement is not good. Police पकड़ेगी ये country liquor लिखेंगे तो oral agreement is the best agreement. And then they also agreed to it. But then the ladies said, तो आपको वन देवी के पास आना पड़ेगा, हस्बैंड को बोले सर, और उधर प्रतिज्ञा करनी पड़ेगी कि हम 2 ही दिन आपको घरवाली को भेजेंगे. I was surprised. What is one Devi? I had heard Kali Devi, Lakshmi Devi, Saraswati Devi. Then they said that one Devi means tree. They treat tree as God and goddess. And all husbands also agreed to it. And they took the place. I am sure that it was an illegal agreement. Oral agreement was also illegal agreement. I have no doubt about it. But today also when I close my eyes and just try to see the faces of those ladies, the tribal ladies, I can read the satisfaction on their face, the smile on their face. They were very much convinced. They were very much happy. Therefore, sometimes what happens that even if the agreement is not a valid agreement, that may produce peace. But you are the best judges of our state, and you can decide what to do and what to do, what not to do. Friends, today's subject, importance of ethical dimensions in mediation. This is one of the most important topics, as ethics and morality are the basis of mediation. The mediation process is a private negotiation process. It is an elastic process. It is a flexible process, and the role of mediator is also most important. And therefore, three basic qualities are prescribed for mediator. A mediator must be an experienced person. A mediator must be an expert, and mediator must be neutral. These are the three basic qualities which are very important for becoming successful mediator and to see that settlement is arrived at. Unless he is expert, the settlement will always be slow, and therefore these three basic qualities are required to be observed by each and every mediator. Now, these three qualities are one thing, but one thing is certain, that mediator has to remember that it is not an adjudicative process where a neutral judge or an arbitrator will decide the outcome of the process. Mediator has to ensure that the final settlement agreement is in accordance with law and it is not unlawful. We shall discuss the few main ethics which are to be observed and fulfilled by the mediators. Those qualities or those ethics, they are mainly impartiality, then confidentiality clause, honesty clause, self-determination by the parties themselves. Mediators should not have any personal interest in the litigation or the result of the litigation. Mediator must be an eligible mediator. He must possess integrity. And at the last, he should not publicize that he is a successful mediator. Publicity is not permitted. Now, fulfillment of all these ethical principles will create confidence in the minds of participants. Parties will feel that they are safe in the hands of mediator. They will feel that mediation process is safe for them and there is nothing wrong in trying it. They will feel that the doors of the court are not closed for them, but if the mediation fails, if it is not successful, then they can re-enter the door at the courtroom. Therefore, these all things are very important. Now, one thing is certain, that they must be satisfied that there will be speedy solution of their problems, and confidence will be created about the mediation process in them, that if the settlement is arrived at, then relationship will continue for all time to come. Now, the main principle of mediation is the confidentiality clause of the discussion. During the course of negotiations, offers are made by and between the participants. All these offers are like giving and taking, giving something and taking something. In order to get something, a participant may give something. This giving and taking of something is the process of mediation. Though mediator has to remain neutral, he has always to see and try that the negotiations do not fail and the process does not collapse. At the same time, mediator has to keep one thing in mind, that the end, as far as possible, the negotiators, the parties, they resolve their dispute and depart with the smiling faces. But if the resolution is arrived at by hook or crook, then it will not last long. The participants may feel peace for a short period, but that peace will not have long life. Therefore, it is most important that participants themselves produce wise agreement. Wise agreement, the word wise agreement is very important in the entire process. The agreement which was arrived at between these tribal ladies and their husband, it was not a wise agreement. It was not a lawful agreement. It was unethical agreement. The agreement must be ethical. If the agreement is unethical, then what will happen? It has no value. If the case has been sent to the mediation center by the honorable courts, then at the end, it will have to be sent back to the court. And the court will also read the settlement agreement. And the court will certainly not take it on the record or may ask the lawyers about its legality. And what will the lawyers have to reply? Lawyers will have to admit that it is not in accordance with law or it is not as per settled principles of our day-to-day life, or it is against the morality and humanity. Thus, the agreement must be a wise agreement. Here, wise agreement means enforceable not only by the courts, but it must be acceptable to our society in which we live. Thus, the ethics is the base of each and every negotiation process and each and every mediation process. Now, today, we will discuss those 7 or 8 ethical principles which are there to be observed by the mediators. First of all, I will discuss impartiality in short. If mediation is impartial and the process is well described, both litigants will feel full safety during the trial. But they are to be explained. The mediator has to explain the impartiality. If a slightest doubt is born, it may fail the mediation. I have come across a case wherein mediator was Gujarati. In the case of our city civil court, mediator was Gujarati, and one of the participants was also Gujarati, but the other participant was not. Mediator just said, he was not serious, but he said that well, all good Jews, we are all good Jews, and all good Jews are soft and more practical for the settlement. Now all good Jews are soft and more practical for the settlement. The other participant felt that mediator is not impartial. This was not expected from a seasoned mediator, as non-Gujarati participants felt bad. And therefore it is highly improper for the mediator. He has to keep his eyes and ears open, but he has to keep his mouth shut as far as possible, as far as needed. Not only that, he must be impartial, but parties also should feel that the mediator is impartial. Mediator is not partial. Therefore, that is the first important ethical principle, and that will create confidence in the minds of the participants. The second important principle is confidentiality, gopniyata, guptata. In a matrimonial dispute, we find that the disputes are so many there in the family courts. In one matrimonial dispute, in the joint meeting, the husband tells that wife has continued the relationship with her former lover even after the marriage. The wife admitted that before her marriage with her husband, she was in love with Bablu. Bablu is the former lover. But she says that after the marriage, she is not at all keeping any contact with the former lover Bablu. In focus, the husband shows recent WhatsApp messages of wife with that former lover. These mobile phones, they are also the reason for divorce. In caucus, the husband showed the messages. He also showed the photograph in the garden and cinema hall of his wife and that lover. But he requested the mediator to keep that information in confidence, as the trial is yet to begin and mediation settlement may not arrive. Then it is the pious duty of the mediator not to disclose that information to wife or her lawyer or to the court, because many times we have observed that it is not good for the judges also, but the judges usually ask क्या हुआ मीडिएटर में क्यों सेटल नहीं हुआ, तो फिर वकील को लगता है कि अगर उसको इंफॉर्मेशन नहीं दूंगा तो दूसरा केस मेरा बिगड़ नहीं, तो वो बेचारा बोल देता है. So this will increase the confidentiality, will increase the comfort level during the negotiation. The third important ethical principle is self-determination. पार्टी को खुद को डिसाइड करना है क्या करना है एग्रीमेंट. Parties themselves have to arrive at an agreement voluntarily, without any pressure or influence of the mediator, of the lawyers, or even of the outsiders. So even if the difference between the parties is narrowed down to a great extent by parties themselves, say 80% of the dispute is settled between both the parties, 20% they are still discussing. But then mediator should not pressurize the parties to forget 20% and settle rest of the thing. What should the mediator do? Instead, he may adjourn the talks for 3 to 4 hours or on the next day morning and request the parties to meet again in the evening or on the next for fresh beneficial talks. That may work, but the resolution should be by the party, of the party, and for the party. We had heard in the past, by the people, of the people, and for the people. Here, mediator is to be should be done by the party. It is of the party, and it should be for the party. That is why it is important, and it will last forever. If it is self-decided agreement, it will last forever. It will not, nobody will commit the breach of that agreement. The fourth important ethical dimension is personal interest of the mediator. A very bad thing for mediation, because many times it happens that mediator has personal interest either in the result of the mediation agreement or in the parties of the mediation. Mediator must not have any past, present, or future interest in the fruits of the litigation. Neither the issue nor the parties should have any connection with the mediator. Say mediator is appointed in a dispute of specific performance of agreement for sale of a land. Agreement is already there, but then dispute has started. The mediator lives in a house on the adjoining land. He desires to purchase that disputed land after the dispute has been referred to. But he does not want to purchase the land which is a dispute. He wants to see that the dispute is resolved and the agreement is cancelled. So he is indirectly interested in the cancellation of that, so that later on he can purchase the clear land. तो क्या करता है वो? He pushes the buyer to cancel the agreement and take back the earnest. अभी तू लेगा ना ये परचेज करेगा लैंड, तो अभी तू सुखी नहीं होने वाला ये डिस्प्यूटेड लैंड. So an impression is created. So don't purchase this land. But that vitiates the proceeding, and it is highly unethical for the mediator. The mediator must disclose in the beginning that this is the dispute of the neighboring land. He is staying in the house next to this land, but he has no personal interest that will benefit the mediation process. The other side will always appreciate his honesty. The next is eligibility of the mediator. Eligibility is a very serious thing. I have personally come across a matter in which father of a very rich person, litigant, he had died on the operation table before the operation was performed. But father was suffering from tuberculosis. He was also suffering from asthma. He was also suffering from heart expansion. And on the operation table, the help of orthopedic surgeon was also taken because the He had fallen down and he had sustained a fracture of the leg. The anesthesia also had come. But before anything could be done, the father died. And the rich litigant was very angry. All the doctors are negligent. They have killed my father. That was his fault. And the judge appointed a lawyer as a mediator. Now doctors were not happy. Lawyers क्या करेंगे अभी इसमें? ये आदमी है मर गया. इसकी तो एज थी 94 years. अभी इतने तक तो जिलाया, फिर बाद में कैसे जिलाएंगे? तो जिएगा मरेगा कुछ भी नहीं. 94 का आदमी मर गया तो भी क्या? लेकिन they were not at all happy with the lawyer as a mediator. Therefore, mediator must be eligible mediator. He must possess the qualities of a good mediator. And if it is such a medical matter, the court also should see that it appoints a person who has got the eligibility to decide or come to a conclusion. The next is honesty. When one of the participants is rich and strong, but the other participant is poor and weak, this happens many times, then mediator should ensure that the poor and weak participant feels comfort in the presence of that rich party. There are disputes between employer and employee. If the employer, in order to get some relief from mediator, he thinks that mediator will be able to help him, he sends a mobile phone directly to his house. The mediator should not accept that gift and sweetly but openly discourage the rich person, so that in the next week he may not send him more precious gifts. Mediator's honesty is in the base of mediation. It is the base of mediation. The rich should not be treated differently than the poor one. The strong should not be treated differently than the weak. Then integrity is also one of the factors. Integrity and honesty, they are practically the same. Then the dispute is for the recovery of 10 lakhs. The defendant has taken a defense that the promissory note does not bear his signature. But during the discussion, he agrees to pay 50%. 5 lakh de dunga, chalo 10 lakh. But at the same time, he shows the promissory note to the mediator, the original promissory note. That, sir, you are a senior person, experienced person. You can decide that my signature has been forged on the promissory. Please compare it with my wakalatnama. Please compare it with my written statement. And if you say that, yes, my signature is not there on the promissory note, then I will pay him 5 lakhs and I will also pay you rupees 1 for your opinion. Mediator has to inform him then and there that he has got no authority to decide anything. He is merely a facilitator. His opinion has no value and he also cannot define anything. He has to send the case back to the court. And lastly, about publicity. There are many mediators who go on talking in the public that now they are more in the mediation than the court practice. So last week also, I have solved a problem between a PWD contractor and the PWD department. It was a problem of construction of a bridge on the river. Very, very, very complicated problem, but I solved it. And I saw that mediation settlement is arrived. So these are the main 8 qualities or ethical things which a mediator has to fulfill. Now the next thing is, can a mediator be summoned as a witness to depose about the mediation talks by the court? Because there are many litigants who are afraid that the mediator will be summoned by the court and he will have to depose before the court. The answer is in the negative. As mediation negotiations are confidential, Mediator cannot depose in the court about the offers given before him and how the mediation, how the mediation was conducted. Mediator cannot depose that X was unreasonable, Y was reasonable, and Z was a hard bargainer. He has to keep his mouth shut. Mediator is not a judge. He has to remember that he cannot decide and describe the fault of any of the parties. And mediator is required to destroy the knots made by him in the negotiation. I think that this is over so far as the qualities of mediators are over. Sushila ma'am, can you take over from here? I have delivered this lecture for the first time on the webinar.
No, it was
I'm
wonderful.
not comfortable to
All the aspects. We are really grateful to you. And you have said everything. It was so nice. So nice. Now I request.
Sahib and myself have worked together in number of meetings of mediation.
No.
Milaben,
That's what I was going to tell. All speakers were too good. It was really, really very enriching learning experience. And we learned the nice integrities of the stages of mediation, the role of mediation. Some of the phrases maybe we had heard about, but didn't know the deeper meanings like lateral thinking, six-head thinking. These are all words and phrases, we never thought of that this could have this meaning. And it was really very nice. The role of mediator and the role of lawyers was very interesting because the lawyers are the main driving force as such, who could make a difference in the success of mediation movement. So it was very nice. And lastly, Paresh Bhai also enlightened us about the all importance of ethical dimensions of mediation. So I would request my co-chair, Justice Shastri, to say a few
yes. Yes, thank you. My pleasure. Good afternoon, everybody. Today we have a proud privilege to attend such an important mediation movement, which is recharged with the efforts of Honorable Justice Dr. Vinit Kothari, an Executive Chairman of Gujarat State Legal Service Authorities. We must congratulate Justice Kothari for his efforts. By now, we have clearly understood the concept and significance of mediation. Looking to the present structure of our judicial system and its multiple issues, this concept of mediation is the need of hour. It would be the most effective alternative dispute resolution mechanism, but subject to what my sister Justice Trivedi conveyed about legal efficacy. In-depth idea is given by Honorable Chair and co-chair persons and respective speakers. So I just wish that this movement be effectively engineered and encouraged. Without much taking time, would like to thank our speakers who took on the subject at a very great length regarding process, stages, and role of parties, lawyers, mediators, which is of immense significance. So request all of you to take advantage of this and effectively continue the momentum of this mediation system which has been given. Thanking you all, and especially Honorable Justice Dr. Kothari for giving me this opportunity to be part of this function. Additional sincere thanks to Honorable Ms. Justice Bela Trivedi and respected speakers, Srimati Sushila, Senior Mediator, Bangalore, Shri J.P. Singh, Senior Mediator, Delhi, and my beloved friend, Shri Paresh Jani, Senior Mediator, Ahmedabad, and also to Mr. Mulya. Thank you very much. It would be my pleasure.
Thanks to all from my side also, to
I
the chair
think,
and others.
we hope that
thank you so much.
Nobody has any question because we didn't have this
Yes.
question answer round. We have 5 minutes if anybody has any question would like to raise. Nobody?
Namaste, ma'am. I'm H.S. Mulia.
Yes, Mr. Mulia.
Your Lordship, in fact, as your Lordship has pointed out, in the Afghan's judgment, directions has been given that Section 89(2) C and D, there is interchange. So now judicial settlement would be read as mediation and mediation would be replaced by judicial settlement.
No, that would have been the best interpretation. It's not that one has to read judicial settlement as mediation and mediation. That's what Supreme Court has said in, while interpreting Section 89, how faulty it has been drafted. So the Supreme Court has observed like this. If this would have been done, it would have made the best sense of the entire section.
So, Lordship, my question to JP Singh Saab and the other resource persons, in fact, they have projected that the divorce cases can be taken up in the mediation. Obviously, this question, this is not the question which is fitting the subject at present. But as your Lordship has already pointed out that there is interchange between the definitions of mediation and the judicial settlement, obviously I'll be raising the question at the relevant point of time. But my only question is whether the divorce cases can be taken up in the mediation, because mediation is as good as Lok Adalat. So in Lok Adalat, we are not taking up the cases of divorce as provided in the NALSA regulation. So this is, maybe this requires long discussion and deliberation. So this is the only question which I just wanted to place it on record so that the necessary will be done at the relevant point of time. So I'm obliged, Lordship, that your Lordship pointed out Section 89(2) and the draftsman's error in the Section 89. I'm really obliged, Lordship.
Yes. Yes. Any of the speakers would like to answer his question?
Question has already been addressed in some of the decisions. For the first time, when the question of the interpretation of the word consent came under the Hindu Marriage Act, see, reading Section 13 and Section 20, the idea was to see to it that there is no collusion. So if they agree, then will it amount to collusion? Was the question. Then if we go through those three judgments, I'll pass it on to Mulia sir. Probably that will give an answer to this. Supposing 13(1) IA a case is filed under cruelty, and the parties in mediation, they agree for divorce by mutual consent. Whether that mediation agreement, when it comes back to the court, that they have agreed for a settlement and they have agreed for going for divorce by mutual consent, whether it could be accepted by the court or not is another question. Then all these aspects have been covered. I will pass on those three judgments to Mulia sir so that it will give some clarity. And the courts have said it stands on a different footing altogether, so it is permissible. That's where I request, supposing I am not against other people getting trained in mediation. I am not at all against other people from other faculty, for example, other than lawyers, engineers or nurses, anybody getting, but there can be co-mediators. There has to be a person who is trained in law also as a mediator. Then what happens is we will know the effect of, ultimately the agreement must be executable agreement. So regarding that, who will be the right person? Parties may enter into some settlement, but who has to look into those aspects? That is where I request that this must also be taken care of, is my primary concern.
Yes. Any other question?
Can I have a question, please?
Yes.
It's something which, when I was discussing with the Member Secretary, Mr. Mulia, I could come to know that our civil judges and senior civil judges, they're not being included in a training of mediation at the districted level that it is being given. Right, Mr. Mulia? That is what has been.
Absolutely, yes, Lordship.
It is a part of our rules and therefore we're not giving it. In fact, since this is an opportunity, can request Dr. Justice Kothari that if that be the case, maybe, we can start, because when we are talking about, one of the speakers said that now it has started even at a, say, school and the college level. they've started training the people, then why not our judges? So this is and I believe that most of the states in the rules might have included the civil judges and the senior civil judges also. Possibly in our state, if we have excluded for some reasons, maybe there might be some justifiable reasons at the relevant point of time. But now we can also go for it and can start that. So this is maybe you can throw some light. I do not know what might be the reason.
As such, our rules do require many changes, many amendments. Recently, I had the occasion to see, and they are still draft rules. They are called draft rules. I don't know why. And they need to be made regular rules. Since 2007, they are draft rules.
Karnataka Civil Judge, Junior Division, Senior Division, District Judges, all are trained. Some of the High Court judges have also been trained. In Madras, when His Lordship Mr. Justice Kothari sir was there in Madras High Court, some judges took this training, underwent this training. In Karnataka, our former Chief Justice of India, Mr. Justice Mr. Keher Saab, he took the, he underwent this mediation training. Present sitting judge of the Supreme Court, Honorable Mr. Justice Nazir Saab, he has undergone training in mediation in Karnataka. It brings a lot of, I mean, when the persons at the higher level, they get trained in mediation, it's a motivational factor for others also.
Very true.
For example.
Lordship, Justice Kothari Saab, it appears that his Lordship is not online. In fact, Lordship, Rule 4 of our rules, 2007 rules, provides that it should be given to the lawyers having standing of 10 years, retired High Court and Supreme Court judges, additional district judges, principal district judges, Rule 4 of Part 2 of the 2007 rules, Lordship. But it does not speak about training to be given to the senior civil judges, senior division and junior division. So this is the lacuna, and because of that, Lordship, we could not give training to the senior civil judges, Lordship.
There doesn't seem to be any logic behind this.
Yes, Lordship, in fact, we have requested the registry, and in fact, process was started, but because of the COVID period, the Honorable RG Saab could not proceed further. So we have floated the proposal to amend the rules with respect to giving training to the senior civil judges, junior and senior division both. So will be done within no time. And Honorable RG Saab was absolutely after it, but due to COVID period, we could not do it. And another difficulty was that in this rule committee, there are 3 or 4 designated senior counsels, and they insisted that because of the COVID period, they cannot come, and this requires serious deliberation. So physical presence is required. So it could not be done at the relevant point of time. But since now situation is becoming conducive, maybe within short while from now, we'll be able to do that.
With the permission of the chair.
Of course, Niranjan Bhai.
Justice Belaben.
Yes.
Rightly raised an issue at the beginning that we should have an exhaustive law on mediation. At that time, Mr. J.P. Singh had conveyed that there was a committee appointed by the Supreme Court, Mediation and Conciliation Committee of 10-member committee. And we have all drafted a draft of the Mediation Act 2020, which is very exhaustive. It provides for domestic mediation. It provides for definition of mediation. It provides for pre-institutional mediation. It provides for online mediation. It provides for giving the status of an award of the arbitrator when mediation agreement is made even outside the court. So mediations is likely to be accepted mediation agreement as final and conclusive and effective between the parties. It also provides for Mediation Council of India. It also provides for registered mediator with the council. The court annex mediation also is covered in it. More widely, how it should be constituted. There should be participation of lawyers also in organizing mediation, in court annex mediation. It also provides for international commercial settlement agreements. It also provides for international mediation centers, settlements, and therefore, if this act is passed, it will have more wide application all over the country. So probably the MCPC of Supreme Court has approved that draft, and it is probably pending before the Parliament. And it will be done, I don't know, because of the pandemic, probably it might be delayed. But if it is finally passed as a statute, what Belaben has suggested, Justice Belaben has suggested, will be available to us in our country.
Let us hope that it sees the light of the day soon.
Yeah.
And at the end, on behalf of all of us, I really salute the commitment of Niranjan Bhai. He is really following the cause since last so many years. And I'm so happy that it is now in the pipeline. The law is in the pipeline. So thank you so much, everybody. Sadhna ji, Sushila ji, Mr. JP Singh, all eminent speakers, and the participants. Thank you so much. Thank you.
We are also thankful to you.
Shall we conclude, my lord?
Yes, yes, Mr.
Thank you very much, my lords and speakers, for guiding us in the today's sessions. After the whole day's exercise on the subject of mediation, now with the permission of my lords, we may call end of the day. Hope you all have enjoyed the sessions of the webinar. See you all tomorrow at 10 a.m. through the same link. Till then, goodbye. Have a nice day.
With new energy.